New horizons, innovation that drives transformation, collaboration that unites strengths, engagement that bridges industry, policy and people.
For this very important topic that we are going to have in our national seminar on GSTAT, we have with us our chief guest, Honorable Justice Sanjay Kumar Mishra ji, President GSTAT. May I request all of you to give a big round of applause for our chief guest. May I request our chairs and co-chairs to please join us on the stage. Shivam ji, please join us on the stage. Sandeep ji, may I request you to please join us on the stage. I warmly welcome all of you to this very important session today. I also welcome our dignitaries and guests of honor, those who are here for the other session. Shri Mayank Jain ji, most welcome to the chamber. Rajiv ji, most welcome to the chamber. Pramod Jain ji, we welcome you to the chamber on this very important topic that we are going to discuss about National Seminar on GSTAT. We have with us Tushar ji, co-chair of the Indirect Tax Committee. We are just waiting for Ashok Batra ji to please join. Requesting Ashok Batra ji please join us on the stage. He's the chair of our Indirect Tax Committee. Before we start the session, may I request all of you to please stand for National Anthem. May I request all of you to please be seated, and also I request you to please put your mobile on silent mode. Once again, very good morning and very warm welcome to all participants, dignitaries on the dais, off the dais, respected speakers, those who are here, member of tax fraternity, industry representatives, legal experts, and all participants. Warm welcome to PhD Chamber of Commerce for this national seminar on GSTAT. We are going to talk about law, practice, and strategy. On behalf of PhD Chamber of Commerce, I once again extend warm welcome to all of you. PhD Chamber of Commerce has been working as a catalyst for promotion of industry and trade for the past 121 years. It's a long, old organization. In fact, now it has become more young. It's 121 years now. It is a forward-looking, proactive, and dynamic pan-India apex organization, and is a partner in progress with industry and government. This conference has been conceptualized as a platform to deliberate upon the legal, procedural, and practice dimension of GSTAT implementation. And we are privileged to have with us eminent policymakers, judicial experts, senior advocates, chartered accountants, tax professionals, and industry leaders to discuss about the opportunity, challenges, and deliberate on this topic. As we discussed today, will be focused not only on the statutory and policy framework, but also on the strategic preparedness for the litigation, management, and compliances. So with that, I would request, first of all, our chair to formally welcome our chief guest and present a memento as a token of our appreciation and gratitude for sparing your time and being with us. May I request sir to please present a memento to our chief guest. I'll also request our co-chairs to please join in presenting this memento to chief guest. Honorable Justice Sanjay Kumar Mishra ji, President GSTAT. Thank you so much, sir, for being with us. May I now request Ashok Batra ji, Chair of the Indirect Tax Committee, PhD Chamber of Commerce, to give his address.
Good morning. Honorable Justice Sanjay Kumar Mishra ji, my co-chair Shivam ji, Tushar ji, Sandeep ji, sitting members, professional colleagues, ladies and gentlemen. At the outset, I would like to thank the Justice sir for giving time in this program. And this is a very timely program. Now, after 7 years, we have seen that GST appellate tribunal has become a reality. If we look at the history of indirect taxes, we already had subject-wise tribunal earlier. There was a VAT, there was CGAT, and income tax. And now we are having GST appellate tribunal, wherein there are 31 state benches sitting at 45 locations. If you compare it with income tax, there are 63 benches, but then their assessee base is 3 times as compared to our registrations and our clients. This is a specialized tribunal. With the introduction of this tribunal now, the whole dispute resolution mechanism has become complete. We had adjudicating authorities, we have appellate authorities, now we had the tribunal, then High Court and Supreme Court. Looking to the fact that tribunal is the final fact-finding authority and a statutory court, it has its own limitations and advantage. The advantage is in the sense that they are all specialized members, deals with the specialized subject, and we have seen in the past that GSTAT has done a wonderful job, and most of its order, if I quantify them, more than 97% orders are being affirmed by the High Court and Supreme Court. That is the quality of these tribunals. And once the tribunals are there, it is a cost-effective remedy available. But then, coming tribunal after 7 years is coming with the challenges. This is the first ever tribunal which will start as a digital tribunal. There is no paper filing at all. We have seen now, even in GSTAT after 1st January, we are all filing online papers. There is no physical paper being filed in GSTAT today. But yes, with the infrastructure coming, and this being the first digital one, and there is a GSTN portal, I do appreciate and share with you that there can be teething trouble in the initial stages. But ultimately, as we have seen, when the GST was introduced, there have been a lot more problems with regard to the filing of returns, and now how the process has become very smooth. Similarly, we have seen ROC portal working very well, similarly income tax portal. There are certain mismatches. I was talking to Honorable President when we were having a tea, that in Rule 110.5 they talk about court fee in addition to the pre-deposit, and then that court fee is not applicable because the interest word is not being there. But in any case where there is no tax, interest and penalty, the minimum fees of 5,000 is to be paid in addition to the pre-deposit. Yesterday we were uploading an appeal wherein only interest was being involved, and the tribunal was asking us to pay 25,000 rupees rather than 5,000 rupees. Anyway, it is not a big issue because there have been number of issues. We have raised the concerns, and to my utter surprise, these people are really very, very fast addressing your problems, and things are getting better and better every day. And I am sure within short span of time, this GST, this portal, e-filing portal, will also match with the law. Then this tribunal is posing a challenge for all of us, for trade, for industry, and for members also. First of all, around 5 lakhs appeal, more than 5 lakh, it is exactly 5.5 which is being quoted, are the appeals decided by the appellate authority, assuming 10% orders are there, which are in favor of the assessee. Then 5 lakh appeals have to be filed by the trade. And then out of that 10%, 50,000 audit department will also go in appeal in 80% cases. So almost 5.4 lakh appeals are to be filed by 30th June 2026. And as per yesterday data, because that is the live data, there are more than 8,000 members being registered. But so far as appeals are concerned, only 11,400 appeals have been filed. From this dais, I'll request all of you, either you are trade, from industry, wherever your appeals are ready. I know nobody wants to pay the money in advance because pre-deposit is a very huge amount, so people might be waiting. But kindly also anticipate from the angle of the government, if all the appeals will come in the last week or quarter, how the system will work. Because it's the technical system, glitches will bound to come. So my humble request to all of you, kindly expedite the filing of appeal. Then the challenge for the members are, because they are getting legacy of 5 lakh cases, 31 state benches, 1 principal bench, 32 bench. Even if they adjudicate 100 cases, it will take 156 months to do. But it is not so difficult as it appears it to be, as the Honorable President was saying, because there are common issues involved in it. We have seen in the larger bench earlier session also, once those issues are being decided, then guidelines is being laid down, and on the basis of that, bunch matters are being decided. Of course, all appeals are individual appeals, facts are there, it will be a challenge, no doubt. And from this platform, I want to request him also to request the government to come out with some kind of a amnesty, so that this backlog can be reduced to a minimal extent. That is really important, and this is what is expected. Then, sir, I know as a court you need the cooperation of the councils also, and you also want that the appeal has to be filed in a structured manner. So I'll request you to answer in your deliberation what precaution we professionals should take and how we should file the appeal, so that it is comfortable for the court to answer it, number one. Number two, you can also guide us how we should represent our cases. And I don't know, because nowadays everybody is working with digital devices. For example, Lakshmi Kumaran from Shiva Mehta is there. I have seen even Lakshmi Kumaranji, who is around 70 now, is also coming with the iPad. Narasimhan, I meet him daily, almost daily. He also argues on the iPad. So in case the government can come out with a common software which is there on your desktop and which is there with us, so it will help us in arranging the things. Because if I am using a different software, I will go according to that software only. So I don't know how much it is workable, but this is one again suggestion which you can give it to the government, that they can devise whatever software they have devised for the members. If a similar kind of application or software can be developed for the industry, we can also do that. Sir is looking at his watch, and I also understand you are here to listen to him, not to me. So I will not take any time further, and request Honorable Justice Sanjay Kumar Mishra, President Sahab, to address the audience. So far as his introduction is concerned, he has already told me that he is not interested in listening to the long biodata, so I am not reading anything else because it doesn't need any introduction. He has been President of the High Court. So over to Sanjay Kumar Mishra ji, please.
जगन्नाथ स्वामी नयन पथगामी होते हैं. गुड मॉर्निंग इन जय जगन्नाथ. Honorable Sri Ashok Batraji, Chartered Accountant and Chair of the Indirect Tax Committee of the PHDCCI, Sri Shivam Mehta ji, Co-Chair, Sri Tushar Agarwal ji, Sandeep Garg ji, Co-Chair, my brother Justice Mayank Jain, Member Judicial Principal Bench, Brother Rajiv Kapoor, Member Technical Delhi Bench, Sri Pramod Kumar Rai, Judicial Member Rajkot, leaders of the industries, tech professionals, ladies and gentlemen. It's rather a privilege to address a mixture of tax professionals, chartered accountants, advocates, and leaders of the industries here at the PhD chamber. While we have discussed the mechanics of law with legal professional throughout the country almost, I have been traveling to different cities to propagate the GST-80 outreach. But this is a different situation now. Now, many of you are already appearing before the GST-80 principal bench. One or two I can see. And there are also leaders of the industries, captains of industries. The business leaders are the pulse of the economy. And we see the tribunal as the guardian of tax justice. Few months back, the Honorable Prime Minister said that the motto should be Nagarika Devo Bhava. The Finance Minister, while launching the GST-80 on 24th of September last year, modified that to our context and said that Karadata Devo Bhava, means a tax official should treat a taxpayer like a a honored guest rather than a mere taxpayer or a client before him. With the help of my brothers, we have modified that for the GST-80 also, and we call Apilarthi Devo Bhava. Those people who will come before are appellants, second appellants. It may be revenue, it may be industry or a individual taxpayer. That doesn't mean that we'll go संक और धूप लेके उनको पूजा करेंगे, नहीं. हम उनको अच्छी तरह सुनेंगे. We'll hear them very patiently. We will decide fearlessly. Chairman was speaking about the achievement of the C-Star and also expecting us to follow suit. Here I'll just share one experience of mine. I was hearing in a seminar, a very senior judge of India said that we are all young additional district judges at the time, congregation in the Eastern Zone. A very senior judge, I will not take the name right now. He said, he retired as a judge of the Supreme Court. He said at one point of time, our predecessor had the luxury of judging cases and rendering justice. Now, because of the volume of the cases, the number of cases that were being listed before us in our board, we hardly have any chance to do a real justice. What we are doing? We are deciding cases. न्याय तो नहीं कर पाए, निर्णय कर रहे हैं. अभी हाल ऐसा हो गया है. मैं देखा हूँ. I have seen a judge. I work in 3 high courts, so I'll take which high court it is. You have to guess it. A judge will be sitting taking 100 cases a day and disposing all the cases, saying, go to the respondent, he will hear you and dispose of your representation. ना न्याय हो रहा है, ना निर्णय हो रहा है, निस्तारण हो रहा है. So this is the difficulty of numbers. It all depends actually. I was also talking to the chair and the co-chair. They treated me with a nice cup of black tea and also took some information from me. In the process, they say that, sir, if you sit also in 32 benches, 31 plus 1, and gave me a figure, maximum this much cases can be done, and that means that at least 156 months will take to dispose of the pending cases, जो file होगा 30th June तक. My response was that most of the cases will be bunched because it will have the same fact and law, like classification, like mismatch of the returns, 3B, 2B, 2A, you know better. Once that is decided, the law is settled, everything else will go on like a flow of river. But initial stage, we need your help. Your help in coming to a just and proper conclusion. There is also a point to be discussed, which says that what will define success of GST 80? Now, success is always a subjective term. For a person, success means a lot of money, but for a person, it may be a political power, unquestioned political, or for somebody, it may be a flawless career. We cannot give a 100% what do you call answer to what should be the success of the GST 80. But two things you can try to achieve. Number one, legal certainty. If everywhere in India decides a particular type of case in a particular way, and the industry as well as the professions are sure about what will be the decision of the case, what should be the decision of the case, and it is followed, then a legal certainty will be achieved. Second is, of course, definitely numbers, because how many cases are being filed? There is a lot of speculation going on. Somebody says that somebody reported in the newspaper that I told somewhere that there are already 582 cases decided by the First Appellate Authority. I have not done so actually. Once I was speaking, it should be around 2 to 3 lakhs. That has been filed. We do not know how many cases has been decided, because there are two types of disposal. One is physical disposal on pen and paper, and one is disposal through the portal or the digital. As far as digital disposal is concerned, we have that figure, but we do not have the figure about the physical. That is being gathered, and it is very difficult, because there is shifting of office, there is shifting of creation of new divisions, vagara vagara. So, one thing is sure, if there is a legal certainty, numbers will not be a problem, because once there is a set law, and this is a very new law, and we cannot be sure that 90% of our cases will be definitely be upheld by the High Courts or Supreme Court, because we really do not know how the जैसे ऐसे कहते ना अंग्रेजी में कहावत है, we do not know how the cookie will crumble or which way the cat will jump. बिल्ली चल के जा रहा है एक वॉल के ऊपर, आप प्रेडिक्ट कर सकते हैं यहाँ जंप करेगा, लेफ्ट जाएगा, राइट जाएगा. So now it is very difficult to say that this case has to be decided this way. We have to hear. There will be definitely split decisions and differing opinions among the benches. That has to be bunched together again, and a decision has to be taken which should be binding on others. But we definitely will try to do justice, and whenever there is impossibility or impracticability in doing justice, I will decide cases. लेकिन एक बात हम बोल देंगे, हम निस्तारण नहीं करेंगे. We will not dispose of cases for the sake of disposal. That I can assure you. For my sake and for my brothers, I have extended the relaxed scrutiny framework till 31st of December. Are you aware it? 14th May 2026. This is another olive branch I am offering you. But I must tell you that we are flexible on how the procedural technicalities are met. But will be firm on the question of timeline. 30th June, we should not forget in any way. There is another order I have passed, administrative side, the question of law versus fact. Now there is a lot of talk that 30, 50 lakhs or below, it will go before single bench. But if you read the provision carefully, it shows that, lays down that an appeal having value 50 lakhs or less, without having a question of law involved, with the permission of the president, can be heard by a single bench. And this permission aspect can be delegated to the vice president of the bench. So there are three conditions. Now this 50 lakh is no problem. President's consent is no problem because I'll grant the permission. But the second question remains. The second question is, what is the question of law? Now all the cases will have a question of law. Am I correct or not? Because there has been no decision. There have been a few high court judgments, very few high court judgments, but there are so many issues that has to be decided. First it will be decided by the tribunal, then it will go to the high court or Supreme, and then Supreme Court, and finally a decision will come. And it will take at least a decade to set a precedent on majority of the aspect of the case. But we should not be feel defeated by that. We should make an effort and go on with the job of doing justice. As I have told, I have been traveling throughout the country. I have covered almost South India and East India and a part of Madhya Bharat. My GST 80 has a cornerstone, a verse from Srimad Bhagavad Gita, chapter 2, verse 50. Some of you might have heard. I think 3 persons have already heard. My 3 brothers are hearing it for the 5th or 6th time perhaps. But the more I read it, the more I think that it is very appropriate for GST professional, be they tribunal members or advocates, tax professional, or even revenue officers. Sri Krishna says to Arjuna, Buddhi yukto jahathita ube sukrito dikskrute tasma yogaya yuyusha yoga karmashu koshalam. This meaning, translation in English will be, a person established in his intellect or equanimity, cast of both good and evil actions in life. Therefore, strive for yoga. Yoga is indeed skill in action. Now, another thing I was sharing with Ashokji while we were having a cup of tea, that there is a lot of talk about the handling of the portal, e-filing portal of the GST 80. Many people are facing problem and say it is not easy to file a case in GST 80 portal. I do agree. It is difficult, not because it has built-in capacity to stop filing. It is difficult because it is a very, very sturdy portal. Supposing I'll tell you, in order to give a digital signature on a short order of adjournment, I have to take about 12 steps on my laptop or desktop to sign it. You understand? Why? What is the need of taking 12 steps? Why such system has been developed? They have developed the system so that it will be a sturdy system, it cannot be hacked. I say it is not impossible, but next to impossible to put a signature of Justice S.K. Mishra by any other person. Because the chronology that has to be followed, or the sequence that has to be followed, has to be remembered. There has to be a dangle, and exactly the dangle should be used on a particular way. Otherwise, you cannot sign it. So this kind of things has made the portal very sturdy portal, very difficult to hack, and in the process they have made it a bit, what do you call, a bit difficult to approach from outside. But another thing I have noticed, initially when we were going to different places along with the two technical members, not tribunal members, technical members who were technical persons who are involved in the development of the portal, or saying looking into the difficulties faced by the taxpayers. Initial questions were regarding portal, how this is to be done, how it is to be done. And our outreach is that if you want to go to the portal, file an appeal, there are few simple tips. Number one, get your case ready offline. Your case should be on your fingertips. All documents ready, saved in PDF or Word file. Then go to the portal. The portal will show you there are several videos, there is a manual, and there is a FAQ. You go through everything very patiently. In first attempt, you may not get all the nuances of the portal, but it will be enough to start the proceeding. Now, go to the portal, have a stable connection, stable 5G connection. Don't go for that phone से करते हैं ना जो hotspot मत कीजिए. Go for a regular lease line and a Wi-Fi stable, and then have a nice working system, operated desktop or laptop. Go to the portal. There is a what do you call icon who says that I'm forgetting the exact name. It is a downloadable spreadsheet. You download the spreadsheet, then go offline. You have already prepared your appeal, then you have to fill in the requirements. Copy paste. We are trying to make it, what do you call, auto population system is we're doing it, but it will be in the second track too. Now the monolithic structure may not support that. So we are basically interested in making it good enough to file. Copy paste. In fact, if you have experience of filing one or two appeal, third appeal, फर्स्ट दो अपील आपको लग जाएगा, 1 घंटा के पास लग जाएगा. But third, fourth appeal will file it in 25 minutes. People who have done it are saying that. But at the same time, one chartered accountant was telling me that, sir, I filed 6 appeal, 7th appeal में नहीं हो रहा है. What is the problem? There is a problem on the net. There may be a problem of traffic also at that time. We do not know. But it should not defeat you, or you should not feel defeated for that. If 13,000 cases already been, roughly 13,000 cases already been filed, we can say that it is not a portal which cannot be mastered. It can be mastered. The only thing is that whether do you have the skill in action. Karmashu Kaushalam. मैं नहीं कह रहा हूँ, श्री कृष्ण जी ने, जगत गुरु ने बोला है, तो करेंगे आप? नहीं, nobody is answering it. Are you going to have a skill in action? Skill in action itself is yoga. So for a tax professional now, filing without any problem, without any difficulty, a second appeal through the portal is a yoga. And for the tribunal members, deciding a case without favor and fear will be yoga. So karmashu kaushalam. In fact, I was asking Ashok ji that we will not give too much long speeches, rather we should ask for some questions. So instead of telling any further, actually I have so many things to say, But keeping it short, and I'll ask your indulgence in questions, putting some questions. We'll take a few questions. Thank you very much. Jai Jagannath.
Thank you, sir. Thank you so much. Anybody who want to ask questions from sir? Pawan, you wanted to ask, right?
Microphone. इसको भी ले जाओ.
So you have discussed about the instructions which you have recently issued for relaxation. So what it means that if we are facing difficulty in arranging the translated order or uploading the documents other than the basic document like order in original, order in appeal we have, but some supporting document we are unable to upload because of the limit, or some copies are not clear at present available with us which may be later available. So whether that relaxation would also be applicable for those documents? So what type of relaxation we have till 31st December?
So actually, the initial, please be seated. The initial period, there was a lot of talk among the registrars of the GST 80, and also some members were raising many issues. So this is actually this relaxation order is not to overcome any difficulty in the portal. It is to overcome the difficulty in general, both for the professionals as well as for the registry, and more so for the members who are deciding the case. Now the ball is in our court. We have to show that we can really decide cases with the given system, with the given infrastructure and the manpower. If in this case there are some 26 points which is indicated by the technical team which will be the defects. If you keep everything, stick to everything, then it is impossible for us to take up any case. After all, we are not clerks. I definitely is not a clerk. I am a Chief Justice. I retired as Chief Justice. So my first order was that do not insist on things which is not necessary for deciding a case. Substance over form. This was also not translated in its proper sense to the scrutiny reporters. Scrutiny officers. They started asking many questions. Then I said that you just have 5 documents besides pre-deposit and court fee, which we do not have any jurisdiction to waive, and the letter of authorization. 5 documents. Number 1, copy of the show cause notice. Number 2, order in original. Number 3, order in appeal. Number 4, statement of fact. Number 5, grounds of appeal. Grounds of appeal and prayer. This last 2 documents can be 1 document also. The appeal memo, where it says that what are the statement of fact and what are the grounds of appeal. If that is given, we will decide cases. And to show that we can actually decide a case, I have already decided a case, Sterling and Wilson versus State of Odisha. Have you read? Anybody? Pawan ji, aap padha hai? Padha hai na? Somebody has visited me yesterday. He said that, sir, I have criticized your judgment. ठीक है, कोई बात नहीं करो. Then we are deciding another bunch of case. That is the jurisdiction of the principal bench. हम वही 5 document लिए हैं. We have not gone into any other thing. There is no court fee in that case. No pre-deposit in that case. only on the 5 documents, we are going to decide another case. It will come in the news or portal or in the what do you call it, social media. 5-6 तारीख तक आ जाएगा. So what I am saying that if you have, मैं मेरे कॉर्नरस्टोन में एक और गीता का कोट करता हूँ. लास्ट में गीता में लास्ट में कहते हैं ना, संजय कहते हैं धृतराष्ट्र को कि जहाँ पे योगेश्वर कृष्ण हैं और जहाँ पार्थ धनुर्धर हैं, तहाँ विजय होगा. राइचुअसनेस, ऑपुलेंस, विक्ट्री, एवरीथिंग विल बी. ये मेरा कन्फर्म विश्वास है. संजय वहाँ भी कन्फर्म था, संजय यहाँ भी कन्फर्म है. आपके पास विजडम है. यू प्रे फॉर डिवाइन गाइडेंस. श्री कृष्ण इज विजडम एंड डिवाइन गाइडेंस. अर्जुन क्या है? ए जेन्युइन ह्यूमन एफर्ट. आप दीजिए, हो जाएगा.
So just one more point.
आपका क्वेश्चन मिला कि नहीं मिला?
Yeah, sir, I got the answer. So basically 5 basic documents are necessary. So sir, while we are uploading the appeal, they are asking for complete appeal set with bookmarking to upload the entire appeal set. And again the each and every document separately also. Sir, every document separately, like wakalatnama, order in original, order in appeal, separate, as well as the appeal set completely with bookmark. So I think that is only appeal set with complete document is enough.
पवन जी छोड़े ना उसको,
हाँ.
आप फाइल कीजिए. 5 डॉक्यूमेंट.
Right, thank you.
Anyone else want to, madam, you want to ask? Yeah, udhar.
Very good morning, sir. So basically, there is a provision in GST rules and regulations that we cannot make any additional submission post filing the GST appeals. Whatever submissions and grounds we have to make at the time of filing of the appeal. There is a provision in the GST rules and regulations. But my problem is actually, sir, in case of the scanned documents, some pages are blank, not very clear and blurred. And instead, in the system also in the custom matter, I got the opportunity to present the matter online because it's a virtual hearing. Sorry. But I didn't get the chance to present my matter in person even after requesting because the documents were not very clear on the scan. But the same problem may arise in GSTAT also. The documents are not clear. Secondly, during the proceedings of the hearings, additional ground or submission may come up in our mind. So we should get the opportunity to present and add the additional submissions.
Madam, you are talking about additional evidence or additional ground?
Evidences and
Evidence.
grounds. Yes, sir.
I'll answer your second question first. Please be seated.
Yeah, thank you, sir.
As far as additional ground and additional document and concern, additional ground, if it is a legal ground,
Yes, sir.
it can be taken even without any pleading, anywhere. Pure question of law. You can raise anywhere, even in Supreme Court. There is no dispute regarding that. Additional evidence, there is a provision. I believe it is a bit strict, but initially, as I have understood by talking to my brother members, both judicial and technical, they will be accepting additional document.
Yes.
If you can impress that
Yes.
additional document is necessary for just decision of the case. सर ये निस्तारण नहीं, न्याय करने के लिए चाहिए, वो मिल जाएगा. And the first question is, remind me, first question?
Sir, actually scanned documents are
Visibility
not
of the
very clear.
Visible. हाँ, scanned copy, actually scanned, you should not upload any scanned copy unless it is absolutely necessary in the portal. Because the portal, any portal, the portal, digital portal does not recognize a scanned document as a
Yes,
document.
Sir. Yes, sir.
It recognizes it as a picture. So what you say, if you are having a problem, supposing annexure AF is your scanned document, you can take a ground in your appeal memo, say that I have filed this scanned document, but because it is not legible, I am also filing a PDF of thereof. And say AF hyphen small a, capital A, B, jo bhi likhe. But it must be clearly stated in your appeal memo. And Definitely, if his scanned copy is not visible, the judge will look into the scanned. Unless, of course, the respondent says that it's not a proper replica of his thing.
Then in that case, we should be allowed to present the hard copies also on the request of the.
No hard copy.
The CBSE की result भी हिल गई अब की बार.
No.
Next question, please. Yes.
Namaste, sir. My name is Rahul Kant. As per the procedure rules, the cause list will be issued 1 day prior to the date of hearing. So I am requesting if it can be issued a week in advance.
वीकली हो रहा है, प्रिंसिपल बेंच में तो वीकली हो रहा है. ओनली जजमेंट जब देते हैं, डेट इज नॉट गिवन, ये होता है.
Okay, sir. My question came because the procedure rule says like that.
नहीं, it says that वीकली एंड डेली दोनों हुए. अगर डेली है उसको कट देंगे, मैं वीकली करेंगे.
Thank you.
Sir, there is a section 109.
Introduction.
Yeah. So I am Yogesh. I am chartered accountant. I am also a qualified lawyer. So my question is with respect to section 109. So there seems to be an anomaly. I am not sure. From my understanding, it's an anomaly. It says in case of difference of opinion, subsection 9. It says if the original appeal was heard by a member of a state bench to another member of a state bench, or where no such other state bench is, now it seems like it says where no other state bench is available. So the earlier word is with respect to other state bench. For example, if a state bench in Jaipur has earlier heard the appeal, okay, and there is a difference of opinion, and there is, let's say, no other state bench. We have a Jodhpur, but let's say we don't have a state bench. Then instead of giving it to a member of a Jaipur bench, the provision says you have to give it to a member of another state bench in another state.
I think you have not read it properly.
Yeah.
दो क्वेश्चन में are you finished with the
Yes,
question?
yes.
देखिए, first thing is that now the questions are not related to the portal. It is related to interpretation of this, the text, which is very difficult in a seminar. It has to be given an authoritative decision by a bench. Then only this question can be answered. Now, as I understand, if there is 4 members in one bench and 2 of the members sitting in a division or sitting of 2 members split in a decision, this matter as per the provision will be referred to another member of the same bench. If it is not, if they are not available means they may be having the same issues or they may be recusing from the case. Then it will be given to the other member of the other bench. लेकिन मैं क्या किया, the procedure rule में I have inserted a provision that the president may, in case of split of decision between 2 members, refer the matter to the larger bench. तो हम किसी अकेले को नहीं देंगे. If there is a dispute, it will definitely go before a larger bench. और अगर आप मेरे प्रोसीजर रूल को चैलेंज करेंगे, वो कर सकते हैं आप, वायरस.
Next, anybody else?
सर नमस्ते, सीए परमकुश तिवारी. सर मिनिमम फाइलिंग फीस 5,000 और मैक्सिमम 25,000. सर एसएससी 2 लेवल में 10% जमा करा के आ रहा और यहाँ भी 5,000 और 25,000 है. तो सर एक हार्डशिप है ना ज़्यादा सर, तो इस पे सर
ये जो रूल बना है ये मैंने नहीं बनाया है.
तो सर थोड़ा
सुनिए, और मेरा कोई दखल नहीं है इसके ऊपर. आई कैन नॉट अमेंड इट ऑल्सो. हाँ, आप अगर this representation as we have received, I was also sharing with
सर ने बोला था ना सर 25,000.
I also share with the chair and the co-chairs while sitting there that at least 19 representations has been received by us from different trade bodies and tax professionals and bar associations, and some of them has been routed through the office of the president and the finance minister.
Okay, sir.
So we have formed a committee, and the committee is looking into each and every representation, each and one by one.
Okay, sir.
And very soon we will be recommending to the government certain amendments in the procedure rules. And there is also one representation about the court fee.
Okay, sir.
हमारा ओपिनियन हम उनको बता
सर,
रहे हैं।
एक-
बाकी सरकार तो आपकी भी है, हमारी
सर आपकी ज़्यादा सुनेगी ना?
क्यों?
सर हमारी कम सुनेगी।
नहीं हमारा कहीं क्या है, आपके सरकार आप वोट दे के लिए हैं।
सर दूसरा क्वेश्चन ये था, जैसे स्टे ग्राउंड्स ऑफ अपील स्टेटमेंट।
आप सरकार के हैं,
बिल्कुल
हम तो उनके मुलाजिम हैं।
नेक्स्ट क्वेश्चन।
सर दूसरा इसी से था, जैसे अभी पवन जी ने क्वेश्चन किया था स्टेटमेंट ऑफ फैक्ट्स और ग्राउंड्स ऑफ अपील में, तो मेमो में सर केस लॉ भी कोट करने हैं कि सिर्फ दो ही दे दें, ग्राउंड ऑफ अपील और स्टेटमेंट ऑफ फैक्ट्स? सर जैसे अपील मेमो बनाते हैं उसमें हम केस लॉ भी डालते हैं, तो करें, अगर नहीं भी करते तब भी सर चलेगा कि नहीं, अगर स्टेटमेंट ऑफ फैक्ट्स ग्राउंड ऑफ अपील ही दें?
आप अगर नहीं भी आएंगे भी तो चलेगा।
चलेगा, ठीक है सर, ठीक, थैंक यू सर।
Yeah, Shagun, you want to ask?
There is no strict rule of pleading.
Thank you, sir.
Second appeal, because CPC is not applicable in its full force. Only that क्या कहते हैं, securing attendance of the yes.
I am Ashok Jha, Chartered Accountant. So just wanted to ask if there is any little chance of extending the dates, like you have relaxed some of the things to December. So any dates relaxation from June to December for filing old cases, sir? As only small cases has been filed till date, only 1 month is remaining. So is there any chance, sir? Little chance?
कोर्ट फी के बारे में मेरा दखल नहीं है, बोला सरकार कर सकते हैं, इस बारे में सरकार की भी नहीं है। Only on the recommendation of the GST Council the government can extend. So I am not qualified. Number one, I am not having that much of salary. वो पे ग्रेड से ऊपर बात है, तो आप that is between you and the government and the GST Council.
Next.
Sir, myself C. Nikhil Jawar from Jaipur. Sir, my question is related to the condonation of delay, or we can say that there are many matters where the orders were uploaded at the GST portal, but the SSC could not check them, and when they checked at the time of recovery notices, and we filed the first appeal rejected our matter on the time bar. And now we will be filing appeal before the Honorable Tribunal, citing that ground also on the time bar, whether our appeal can be accepted on time or not. So this is, I think, very common issue which is faced by all the trade and industry as well as our professions also. So I just request you to throw some light on it.
You see, this I have realized that this is one of the biggest challenges that will be facing everybody, not only the GST 80. You see, the law as it stands now, even the High Court cannot extend the limitation, the cap. एक तो limitation होता है, and then there is a cap on condonation. It cannot be done. But at the same time, we have come to realize that there are so many appeals which has been filed before the Fast Appellate Authority at a later stage because of sheer ignorance or lack of expertise or lack of professionals. So this is a big class, जो कहते हैं American litigation कहते हैं class action कहते हैं. A large number of cases is involved in this case. It is very difficult to predict right now, but if I get a chance, I will say that a one-time amnesty should be there. But that is again speaking in a seminar, not in a judgment. So it has no binding effect. And please, अगर कोई प्रेस रिपोर्टर है, please don't misquote me कि ये amnesty करने के लिए recommend कर रहे हैं बोल के.
I think, sir, as a PhD, we can file a representation on behalf of everybody to Ministry of Finance asking for relaxation in these cases. But as of now, like sir is saying, there is no way that tribunal or even High Court or Supreme Court can condone any delay. That has to be considered as final decided. Last two questions, please. Madam.
Good morning, sir. I'm Shagun. I work with Lakshmi Kumar and Sridharan. I don't have a technical question. I just want to understand what will be the temperament of GSTAT in handling matters relating to reconciliation. Because history has it with CSTAT, we've seen these matters are usually remanded. So like you mentioned, the GSTAT will also be the last fact-finding authority. Will they sit in indulgence to actually see where there is certain reconciliation issues in 2A, 3B, 1, 3B, or there's a likelihood of these matters also again getting remanded and the entire loop being repeated again?
Well, have you read Sterling, Wilson?
I did. So there was an aspect of remand as well. While you did give the order on the aspect of limitation, but when the reconciliation aspect comes into picture, a lot of times we see that the tribunals actually don't sit in judgment to determine those facts. They don't actually sit to verify whether there has been or not has been a
Your question was what is the psyche? What is the mental set?
Will you decide the case of reconciliation, or like CSTAT is remanding the matter back?
Despite being a fact-finding authority, usually the tribunals remand such
you see, that is a very hard question to answer in a QA session. It has to be depend on the facts of the case. You see, I'm a trial court advocate. I will remain a trial court advocate forever, even if I retire as Chief Justice. And I believe that every litigation has its own fate. It has its own identity. It should be treated like a person. So, if my father was my senior, he used to say that do not remand a case unless it is absolutely necessary to do so. Supposing, Joe Sterling and Wilson, it was impossible to have a reconciliation on the GST 80 principal bench because it needed a physical inspection of the document, and it was being done online, paperless, digital mode. And they were arguing from Puri and Cuttack. And I was sitting in Connaught Place, New Delhi. So I had to remand that. But I made an attempt, you do not know the behind the scene, I made an attempt to see if it can be reconciled at my stage. But again, the question of professional, karmashu kaushalam, it was not skillfully placed before me. But if you give all the materials to the members, judicial member and technical member, they will be sitting in division at present, then I think they will decide the case. Because I have told them in their orientation training, all of them, the members, I told them how a remand in one case, in a civil case, destroyed a family. So we'll try to do that. But again, the materials, the facts, and also the karmashu kaushalam, skill in action.
One last question.
Good morning, myself Rajaram Gupta CA. I have a question regarding one particular case. In penalty, it was an appeal against penalty. When we went to the portal, it is showing already amount paid, and paid amount is much more than the penalty total levied. And we have not made any payment. Even in first appeal also, it was before March, so there was no payment. So how we have already lodged the grievance on the portal, but we have not received the replies.
DRC 3A करना पड़ेगा आपको.
We have not deposited any amount, sir. We have not deposited any amount.
It's only penalty amount or tax involved?
Only penalty amount.
Only penalty?
Yes.
But you have never deposited any amount in the portal it is showing as paid?
Yes, much more than that, even more than penalty.
More than the penalty amount?
Yes.
You have not deposited?
We have not deposited.
नहीं होना चाहिए.
But we have lodged the grievance on the portal.
Then you raise
the grievance.
It is already raised, but it is not resolved so far.
Because there is a voluminous number of cases, tickets are there.
Yes.
And sometimes the tickets are very petty things. Tickets are. You see, GST 80 has the entire reach throughout the country. A small town somewhere in Odisha, also in Patnagarh, or say village हड्डा छोटा सा जगह से अगर नेट कनेक्शन है तो वो फाइल कर रहे हैं. They may not be having that kind of professionalism and precision in filing. वो लोग टिकट रेज कर रहे हैं छोटे छोटे इश्यूज में और वॉल्यूम हो गया है, बहुत वॉल्यूम हो गया है.
Yes.
But again, a dedicated team, 3-layer team is working on it. If you can give this, Arshit, आप particulars दे दीजिए मेरे LR को.
Sure, I will provide.
He will take up with the technicality.
Sure, I will take.
One last question,
Thank
madam.
you.
Yes.
Good afternoon, sir. I am Harshita, working with Tatvam Advisor. There's just small question that, for example, there is an order, and at the preamble of the order, the language written is in Hindi. Do we need to translate the entire order into English? This is the first question. And another question is, in a 30-page order, there's 28 pages in English, and there's just 2 pages where there's a reproduction of any evidence or anything in Hindi. Do we still need to translate the entire order in English? This is just 2 questions.
Actually, you have not seen the scrutiny relaxation. There is specific direction. At present, there is no need of filing any translations. In fact, yesterday we had discussed, we will be making an amendment in the rule, giving the discretion to the member concerned to file whether to insist on a translated copy or not. At present, as the matter stands, you are not required to file a translation of that.
In both the cases which I have mentioned. Thank you so much.
So it was nice talking to you. भाषण देना इतना अच्छा नहीं लगता, मैं जज हूँ, भाषण नहीं देता हूँ, so अच्छा. So it was nice talking to you, and very nice to know that except there is 1 or 2 questions, nothing is related to the portal or difficulty in the portal. You have overcome, you have mastered the portal. So thank you, and I wish all the best to all of you. Let there be a real discussion, manthan हो GST लॉ की, कोई निष्कर्ष निकले, और जब जाते समय ज़्यादा क्वेश्चन और कम आंसर लेके जाना. ये मैं हमेशा कहता हूँ. अगर आप कहीं विद्वानों के क्या कहते हैं कांग्रेस में जाए और आपका सारा डाउट चला गया, तो ये ठीक नहीं है. आप यू शुड टेक क्वेश्चंस एंड सॉल्व देम योरसेल्फ in your brain. Thank you. All the best.
Thank you so much.
Thank you so much, sir. And may I request all of you to please give a big round of applause for our chief guest for taking so much of details from each and every one of you. So we were expecting that he might take 1 or 2, but I think he has taken each and every question from all of you and solving to your satisfaction. Thank you so much, sir. I'll request Shivamji to please propose formal vote of thanks, please.
Good morning, everyone. First and foremost, I'll give deepest gratitude to Sanjay Kumar Mishra ji, President GSTAT, ex-Chief Justice, Jharkhand High Court. I think, sir, the key takeaway for me is that GSTAT में न्याय होगा, निर्णय नहीं होगा. That's a key takeaway and very heartening to know that. न्याय के साथ निर्णय होगा, यही I think हम सबके लिए बहुत बड़ा key takeaway है. Second, जैसे आपने कहा, you are not in the favor of remanding the matter, and you are also asking other brother members to decide it there, so that assessee is not circling between adjudicating officer and the appellate. That's another key takeaway and positive sign from the GSTAT. Sir, I can only say you have taken time from your busy schedule and answered each and every question. I think at least this session, ऑडियंस आर गोइंग विद ऑल द आंसर्स. एंड जो आपने कहा कि मैं जज हूँ, स्पीकर नहीं हूँ, आई थिंक आप दोनों हैं, क्योंकि आप दिल से निर्णय करते हैं, दिल से बात करते हैं. थैंक यू सो मच. आई थिंक विल टेक अ शॉर्ट ब्रेक फॉर द नेक्स्ट सेशन. थैंक यू सो मच.
नंदा जी, एक ग्रुप फोटो करते हैं. Thank you so much, sir. And now we will start with our next session. Next session, and next section is institutional framework, appeals, procedures, and pre-deposit practical insight. We have with us our session chairman, judicial member, Honorable Justice Mayank Jain ji. Sir, may I please request you to please join us on the stage. I'll request Yogesh Gabaji to please join us on the stage. Sudeepta Bhattacharjee from Ketan and Company. Deepak Suneja from Chartered Accountant Deepak Suneja, and Dr. C. Avinash Poddar from Ashwa Legal. And I'll also request Shagun Arora to please join us on the stage. Thank you so much, sir, for joining. I will now request Tushar Agrawal ji, co-chair of the Indirect Tax Committee, to moderate the session and take it forward, please. Thank you.
Good morning, friends. At the outset, it's my honor and privilege to welcome the session chairman of this panel discussion, our honorable judicial member, Shri Mayank Jain ji. Sir, we are very grateful for your gracious presence, sir. Thank you so much, sir. I also extend my warm welcome to all the esteemed panelists and the audience. Friends, operationalization of GST Act is one of the major milestones in the evolution of GST landscape in India. We have almost completed 9 years of GST implementation. We still remember those days of implementation, and it has been a continuous learning. From implementation to litigation at ground level, be it assessment, audits, adjudication, first appeal. There is an immense amount of litigation at ground level. There is no doubt about that. But the entire litigation framework has been operating in an incomplete manner. There has been a missing layer, and that missing layer is tribunal. And because of this, a very unusual phenomena happened. The courts were flooded with so many writs, and almost many GST issues went to High Court. Writ is always an exception, not a norm. But now, with the functional GST 80 becoming functional, we are entering into a new phase of GST litigation, a phase which is more structured, technical, and require more preparation with regard to readiness, documentation, and strategic thinking. With this, sir, we will commence our session. Sir, GSTAT has been formed at a time when GST jurisprudence itself is evolving. There is an GSTAT will play an immense role in shaping the indirect tax jurisprudence in India. Considering its immense role, sir, what according to you, your opening remarks, what according to you will be the foremost priorities of tribunal in its initial year?
Thank you, Tusharji. There is a Sanskrit maxim having literal meaning that dharmo rakshati rakshitaha. When we take this maxim to our taxation approach, it means that someone who is approach the GST with clean hands can be assured of receiving true, fair and impartial justice. So it is our motto that dharmo rakshati dharma. We will impart true, impartial and fair justice to everyone who comes before us with the clean hands. Clean hands का मतलब ये नहीं कि आप हाथ धोकर आएंगे. Clean hands का मतलब ये कि आप good conduct से आएंगे. You will tell everything to the bench. You will disclose true facts of the matter, and you will argue your matter in a professional manner without concealing any fact. And we assure you that we will deliver a very good judgment, a speaking order and a rightful judgment. I extend my sincere gratitude to all of you and to my honorable persons on the dais for chairing this session to me. I would like to communicate one thing also, that in our judicial scenario, the litigant interest is supreme always. वादकारी का हित सर्वोच्च है, तो इसलिए हम ये इसी स्पिरिट से काम करेंगे कि the litigant should be benefited in every manner. We should pass speaking orders, we should give them patient hearing, and judgment should be pronounced in such language that everyone can understand what is the idea of a judge to communicate to the litigant. It is our foremost idea. Thank you.
Thank you, sir. Thank you so much for your words of wisdom, sir. Now, coming to our next question, Avinash ji. Since lots of writs are already pending before the High Court, GSTAT was not operational, taxpayers went to the High Court. Now, since GST is becoming functional, what advice will you give to the taxpayers and professionals with regard to the pending writs?
See, so far as writs are concerned, since GSTAT was not there, most of the litigation went to the high courts. But as we all are aware that high courts were not indulging into the matters on merits. At the most, they were staying it with the expectation that GSTAT will begin, and then they will remand it back or send it back to the GSTAT authorities. But so far as my view is concerned, I still have a view that whenever there is a violation of principles of natural justice, or there are certain issues which are to be tested so far as constitutionality is concerned, or maybe the viracy is concerned, those matters will still be there and handled by the high courts only. But yes, when it comes to reconciliation, when it comes to merits of a matter, so far as the facts are to be appreciated, then certainly the high courts will not entertain it any further, and they have started remanding it back, or maybe dismissing it with the observation that you need to file once the GSTAT is there, and it can be taken it forward. The GSTAT will take it forward. Now the only question which comes is that what about the stay of recovery? So at certain levels, the high courts have taken a view that once you are uploading the appeal before the GSTAT authorities and till it becomes operational, so there is no efficacious remedy as such, although the GSTAT is there. So they are extending the recovery till the operationalization starts of the particular bench. That is what they are doing. But yes, the answer would be, the precise answer would be, now the matters which were there on merits will not be considered for sure, but the matters which has the question of law or maybe the constitutionality there, or the virus challenge is there, that those will certainly be continued with the high courts only.
Just to add a particular nuance, and this is something that we are seeing practically, like you rightly said, a lot of writs were filed at a time when, on one of the grounds that why high courts entertained those writs was also because there was no functional GSTAT, no alternative remedy. In many cases, stay has also been granted. Especially there are a bunch of intermediary cases, etc., where stays have been granted. I think what would be very curious is to see when, especially I know this is happening in Allahabad and Punjab and Haryana, where they are now creating a bunch which will get sent back to GSTAT. A lot of them are sitting on stays, full stays, without the condition that you mentioned, that till the formation of GSTAT. Now when I have to move from High Court to GSTAT, do I move without the pre-deposit requirement? Does it need to be a specific order from the High Court when they are remanding it back to GSTAT? Or how does GSTAT, that particular bench, reacts to it? I think that will be something worth seeing.
I can just share one of my experience in Bombay High Court. I was arguing before Justice K. Shriram. So he said, let us presume GSTAT is there. Then what is the option? I said, we'll have to pay pre-deposit. Then you say, you pay pre-deposit, everything will be stayed. So therefore they are remanding it with the expectation that now you will have to pay pre-deposit and therefore it will be stayed.
Moving on. One of the key structural feature of GSTAT is the concept of principal bench and state bench. Sir, for the benefit of our audience, can you explain this framework in detail and how is it different from the existing framework? And also what kind of issues will be taken up by the principal bench and the state bench?
So I think before I get into the specifics, I think what is important is to understand the legal framework under which GSTT has come in. It is not a two-tier tribunal. And this is an important distinction because the original GST model law as it came envisaged a two-tier tribunal. When the final law came, we deviated from that. The whole idea, if you look at relevant state GST statutes, they just cross-refer to 109 and those relevant provisions under CGST. So this is one tribunal. All the benches are flowing from CGST Act itself. What that means is that there is no hierarchy in terms of the benches. They are all like, the closest comparable, of course, is the CSTAT. While there is a principal bench, etc., coordinate benches, the decision of each coordinate bench is binding on the other. So from a certainty of taxes, of course, practically we will see deviations, etc. But from a certainty of tax position, from the value of precedent, etc., I think that's a very critical point to remember. In terms of what would go directly to principal bench, from the Act, it flows that if any one of the issue of 6 or 7 issues, if even one of the issues is pertaining to a place of supply, it will go to principal bench. Further clarifications have been issued by way of office orders, etc. So matters involving supply of OIDAR services, which is basically your digital services, etc., which is one of the huge areas of enforcement today by DGGI. We are seeing, all of you would have read in the papers about strong investigations that are happening against fintech companies, online gaming companies, etc. So I think a lot of those will directly come to the principal bench because of this particular office order. So OIDAR as well as online gaming when provided from outside India. So a lot of the offshore betting platforms or gaming platforms, I think those cases would also come to GST, the principal bench. And lastly, appeals involving ISD. So section 20 of CGST Act. These are exclusively for the principal bench. Rest everything jurisdictionally, depending on your territorial jurisdiction, etc., will go to the relevant state benches. And of course, advanced rulings, the National Appellate Authority for Advanced Ruling, which has just been, that provision was made earlier, it has been actioned now. So the principal bench will also have the authority to hear advanced rulings, contradictory advanced rulings. So if I am an SSC, I have a advanced ruling which contradicts in Karnataka, which contradicts with one in Maharashtra. I have the ability or the entitlement to approach the principal bench in its capacity as the National Appellate Authority for Advanced Ruling. So that's also something that is exclusive to the principal bench. So anti-profiteering is the original jurisdiction. So that's and of course, some of us, many of us would have appeared before the principal bench in its authority as the original judicial body for anti-profiteering matters. Earlier it was, for some time it was the Competition Commission. Currently for the last several months it has been the principal bench.
Thank you, sir. So taking the discussion a step further, from a practical perspective, Yogesh ji, do you see forum selection issue during the initial years of GSTAT working? Like for example, what if a taxpayer files wrongly with the principal bench, whereas it should have been filed with the state bench, or vice versa? Similarly, like what the strategy taxpayer should adopt in cases of say DGI investigation, etc., wherein the demand has been raised in multiple states. The issue is same. You have to file appeals in multiple states. So there, whether the hearing will happen at every state or it will get consolidated at principal bench. So what should the strategy taxpayer should follow? Your views on the same.
Thanks, Tushar. So on the first question with respect to an intentional or unintentional error that a taxpayer has filed an appeal before a principal bench, which should have been gone to a state bench. So I think last month the principal bench has asked the registry to transfer the case to the Delhi State Bench in Manobendra Ghoshal versus, I think, Commissioner of CGST. So I think that's a quite welcoming step, that instead of dismissing the appeal per se, the principal bench has opted to direct the registry. There is also a rule 32 of GST 80 rules, wherein the registry has, the power, the bench has the power to reject or allow the amendment in the appeal. So the registry may also ask the taxpayers to allow, to amend the appeal and file it to appropriate state bench. And I'm guessing that since this was a direction from the principal bench, I think this becomes sort of practice at state benches also. If the appeal was supposed to be filed before principal bench, the state bench would also direct the registry so. To the second point, see, right now we do not have a provision wherein it specifically says that if DGGI has investigated a matter and it has been, the investigation has, gone to like pan-India, so there should be, the bunching of those cases and then principal bench will hear. There is no such provision, but the law has empowered the government to issue a notification that, any class of, cases can be referred to a principal bench. So I think our representation, trade representation, can make it possible that, the government can notify these classes of, cases where they can actually refer it to principal bench. So right now there is no such provision, but we expect so.
We are working on it. On this issue we are working. I think you need not to make any representation or to approach the government. In the principal bench itself, we are doing some work on it, and we are trying to get some cases, identical cases to make a bunch and decide them in a particular bench. Yes. Beside this, 3 appeals have been transferred seamlessly from the principal bench to Ghaziabad bench as well the Delhi bench. There was no withdrawal of the appeal, no rejection of the appeal, and within 10 minutes the appeal was transferred to the concerned bench.
I think seamless transfer of appeals to the concerned bench is actually very good for all the taxpayers. It's not that we have to withdraw, file again, etc. It's a very welcoming step, sir. Moving on to Deepak. Under the GST framework, as President Sir was also saying, cases wherein the dispute amount is less than 50 lakh rupees and which does not involve substantial question of law may be heard by a single member bench. Now in many cases we have seen at ground level, section 74 has been invoked. They have invoked it's either fraud, suppression, willful misstatement, etc. Do you think, and what's your view, whether an issue, reconciliation-based issue, whether 103B or general reconciliation-based issue wherein 74 has been invoked, is it a question of fact or question of law? Deciding a case, whether it is under 73 or 74, is it a question of law or question of fact? Because most of the cases are under 74 at ground level.
So I'll break it into 2 parts. First, only the reconciliation issues as well. So for that as well, if you see reconciliation issues, while it would have some number element to it, those also have some legal grounds. So like at least in the initial period, whether the law mandated it or whether, let us say, if the supplier has not paid the tax, whether as recipient credit can be denied. And we have seen under the VAT laws, there have been High Court, Supreme Court rulings to saying that the recipient should not be punished. So even the 2A, 3B issues which are there, the typical ones, may have a question of law, which may go to in that sense the division bench. And I think in that sense the order or step which has been taken, that all matters first should be taken up by the division bench, and then they decide whether a matter is to go to the single bench or not, even if it is below 50 lakh. I think that's a very valid step. And taking it a step further, so that was on reconciliation, and reconciliation plus section 74. So on the issue of fraud suppression, we have recently seen cases of Allahabad High Court, or for that matter even Gujarat High Court, wherein they are saying that the presence of section 74 or fraud suppression is actually a issue of jurisdiction as well. And they have admitted writs from the order in original, saying that while the GSTAT is there, but because the issue relates to jurisdiction, I'll admit a writ. Even before, under the excise laws, service tax laws, there have been up-team cases wherein what they have done is they have interpreted the word. So one is definitely a factual scenario, but in whether that factual scenario, there is the existence of fraud. So taking an example, I have disclosed the credit in return. My intention may or may not be determined by the officer, but whether that disclosure in the return results in a fraud or not. There have been cases which have earlier reached to Supreme Court and given a direction in the matter. So again, in reconciliation and 74 also, while there will be some question on facts, I believe that may be a mixed question of law and fact, and therefore taken up by division bench.
Perfectly fine. Moving on. My next question is to Shagun. It is important for the audience to understand the GSTAT jurisdiction. So what are the different kinds of orders that can be challenged before the GSTAT? And second, once GSTAT decides on a particular order, what is the remedy available to the taxpayers, both in terms of orders issued by the principal bench or state bench, or orders issued by a single bench also?
Right. So first of all, as to your first question, what are the kinds of orders that can be appealed again before the GSTAT? Like in the initial portion of this conference that we had, sir had also highlighted there about lakhs of orders. Wherever the orders are against the assessee and adverse to the interest of the assessees are going to appeal. And so far as the orders which are unfortunate for the department is going to appeal. So there are certain revenue or I would say monetary limitations that are time and again provided to the department, which put a ceiling above which the department cannot appeal. But even if the department or the assessee feels that there is a question of law involved, the right to appeal and to right to get some relief is always there for the assessee, and therefore every order which the assessee feels is prejudicial to its interest is going to be appealable before the GSTAT. The question now comes as to, sir has already answered the question as to what decision is going to be, or what kind of order or what kind of appeal is going to be handled by which bench, so I will not indulge in it again. From the GSTAT, you have your appellate remedies towards the High Courts and the Supreme Court. In most of cases where you have a substantial question which is involved, you have the right to appeal before the higher forum. Again, the discretion of these writ courts always remain in indulging, in giving you relief or entertaining an appeal from a decision of the GSTAT. We have seen in several cases that High Courts and Supreme Courts do not indulge in interfering with the orders of the GSTAT, especially in cases where they are extremely factual in nature, where the departmental authorities and the tribunals have undertaken sufficient exercise to determine the correct position. In these cases, the higher forums do not interfere and they would like to maintain the sanctity of those orders. However, wherever there is a question of law involved, the writ courts do not and cannot for a fact reject the proposal to file for the appeal that is filed by the assessee. So in these cases, the assessee still has the freedom to go before the higher forums, whereas in cases which are extremely factual, there is a bleak chance. But of course, if you can establish arbitrariness, you can establish some form of unlawful invocation of a provision, you can establish the proceedings were improper that were addressed against you, those cases will still have some remedy available again for you. Otherwise, highly technical, highly factual matters do find their closure at the GSTAT itself.
Thank you. Moving on, Avinash.
I would like to point out one thing, that to ensure speedy justice, there is a limitation of 3 adjournments only before the GSTAT. Only 3, one party can seek only 3, maximum 3 adjournments. And moreover, there is a limitation upon the members, either technical or judicial member, that they has to pronounce the judgment within 30 days after the conclusion of the argument, so that the time-bound justice may be delivered.
I have a question here. So generally we've seen before the tribunals, the members of the tribunals, I would not say, it's not a position of being relaxed, but they're extremely accommodating towards the assessees and also towards the department. The general mindset I feel of the tribunals is that they want to extend the maximum relief and the maximum opportunity for a taxpayer to find closure in respect of their litigation. This intent has usually seen matters continuing for years. And this also gives chance, I would say, an opportunity for the assessee to properly establish its case and then arrive at a conclusion. So this aspect of 3 adjournments, would that still hold strictly, or is it a flexible requirement?
Not so strictly, according to the fact and circumstances of the case. And if you are unable to argue for personal reasons, we can accommodate you very well.
Thank you.
Thank you, sir. Thank you so much. Moving on, Avinash, sir. Sir, under the GSTAT framework, filing of replies, cross objection, rejoinders, cross appeals, these are various important procedural aspects under the entire GSTAT proceedings. Can you, for the benefit of entire audience, explain this concept and how significant it will be in GST, sir?
I think this is a very apt question, reason being there is a lot of confusion amongst the young tax practitioners. They are unable to segregate the meaning of cross objection and reply to the appeal. So I'll give one example and then I'll try to share my view. Let us say there were 5 issues involved in a particular matter. Out of those 5 issues, when you went before the first appellate authority, 3 issues were decided in your favor and 2 issues were decided in the favor of the revenue. So now the option which you have is that you have one option of accepting the 2 issues and paying or discharging the tax liability, if any. The second option is that you file an appeal against the order in appeal before the second appellate authority on the 2 issues which were decided against you. Now when I am filing an appeal on the 2 issues which was decided against me, the departmental authority or vice versa, when department files an appeal and I am there as the respondent, I have an option to file a cross objection. If I am not wrong, the time which is given is 1 month. 45 days is the standard time which is there in C-State also. Now in G-State also it is going to continue. So within 45 days or 1 month, whatever time limit is there, we need to file a cross objection. Cross objection does not mean the reply to the issues which were raised in the appeal. It means the cross appeal. So therefore, I have an opportunity that if 3 issues are, let's say I am reversing my query, 3 issues are raised by the department which were decided against them in my example, then I have a liberty that the 2 issues which were decided against me, I can raise those 2 issues by way of a cross objection. It's not a case that those 3 issues are to be addressed as a reply in cross objection. So this is a confusion which generally people have, that what is cross appeal or cross objection, whether these 2 are same, and the reply to the appeal or the rejoinder. Rejoinder is different. Again, the department or the appellant will have to file it. But the example is very clear. If I'll have to reiterate it, I'll simply say the issues which you are raising. On these issues, if the department or the other side counsel wants to reply, then it is a reply to the appeal. But if we want to raise an issue which was decided in the same order against him, then it becomes cross objection, which is very relevant, and it can be used for the benefit of taxpayers also. I'll give one example. Maybe I am wrong or maybe I am right, I don't know. But there can be a situation wherein the department or the revenue files an appeal, and there are 2 issues which are decided against me also. I can raise a cross objection for that. The question will be pre-deposit will have to be paid or not. My understanding says the pre-deposit will not be paid because that is not an appeal. It's a cross objection. So strategically, but at the same time we'll have to be very cautious because department has a 6 months time, whereas we have only 3 months time. So if we miss on that, it will be a confirmed order in appeal. So we need to work on that. If the department is proactive and they file within 3 months, you have the time limit for filing cross objections and all. You can very well take the advantage of getting away from the pre-deposit also. This is something which we can make use of as a cross appeal or a cross objection. Thank you.
Just one added point I wanted to flag is there is no normal or natural right of filing a rejoinder. You have to take a permission as per the rule, because a lot of us, especially when me included, who do a lot of work at a high court level, we presume that rejoinder is a part of pleadings. That's not the case here. So you'll need to seek permission from the bench for filing of rejoinder. So rejoinder is something that an appellant would file after reading the reply filed from the other side.
Thank you, sir. I think you have aptly explained this concept for our audience. Moving on. Friends, GSTAT is not merely an appellate forum, but a final fact finding authority. Now, GSTAT has been empowered with lots of power, be it examining the witness, accepting the affidavits, permitting cross-examination, etc. Sir, can you explain the scope and significance of this power in detail and how it can be useful for the taxpayers and professionals practically?
Certainly. So I think the best part about GSTAT is it has all the powers of a civil court, but it's not bound by the rigidity of CPC, which I think gives us a huge opportunity to set right a lot of evidentiary best practices, which unfortunately at the lower level, at the first appeal level, that's something that's given a complete go by. There are 3 or 4 aspects that I think is of relevance. One is discovery. Now, if you look at rules 84 and 85, there is a very strong power of discovery by which the tribunal can suo motu ask for production of documents or records from any department or lower authority. Now, this can become very, very critical in high-pitched DGGI investigations. What happens when you see anyone who has handled a ITC fraud case, not at the first level, but if you are the recipient 2 levels removed or 3 levels removed, often you will be faced with something as vague as we have intelligence report, or we have statement from one person who is probably your L3 or L4 who you have never met or interacted with. You don't get a chance to cross-examine, you don't get a chance to review the record of the statements, you don't get to see any other intelligence input. Now, if I have to rebut any charge against me, I should have the full facts with me, including the facts which are in my favor. I mean, that's the whole point of a discovery process in a civil litigation or even a criminal litigation, right? The department, the other side should not be able to hide anything that is in your favor, and they can't say that I'll only present to you the incriminating things. So I think we'll have a lot of opportunity to plead to the GSTAT in relevant cases to say that this case merits a discovery where this particular data point, this particular intelligence report, even if it is not presented to the taxpayer, at least for the benefit of the bench to have a complete picture, I think that's one very critical aspect. Second, of course, like you said, the cross-examination part of it. Unfortunately, under the GST statute, unlike customs or excise, there is no automatic right of cross-examination. It is there only qua prosecution. It's not there for normal appeals. Some high courts read it in as a feature of natural justice. Some other high courts have not necessarily agreed with it. And routinely cross-examination requests are rejected at the lower level by saying that it is not relevant or whatever the case may be. I think because it's the last fact-finding authority, this will be the right forum to really press on for cross-examination requests. The GSTAT has the ability to conduct cross-examinations itself, or it can appoint another authority, maybe a first appellate authority or some other senior bureaucrat to oversee the cross-examination process. And I think that's one thing that as assessees we definitely should not miss out. If anyone has relied on a statement, if a show cause notice is based on recorded statements, you must cross-examine. That's not a right to be given up. And secondly, I think what needs to be emphasized, and this is a very settled law of evidence, that oral evidence will have to give way to documentary evidence. Oral evidence on its own should not be sufficient to fix a liability on you. It has to be corroborated. So that point of corroboration and the second point of documentary evidence, I think is another aspect which I sincerely hope from GSTAT as we go forward as a standard of evidence will come forth. Thirdly, and very importantly, a lot of evidence today is digital evidence. You will see a lot of reliance on WhatsApp chats, mobile phone data, Excel sheets that have been taken from this thing. There is a very clear process of certification under Evidence Act, Section 65B, under the new Evidence Act is under Section 63. In many cases, and I have personally won litigations on the basis that entire evidence needs to be thrown out because the digital certification is not there. 65B certification is not there. Of course, there could be cases where a SSE is sort of being naughty and trying to withhold those certification. Those cases, high courts have also come down against SSE. So I'm not saying that it's a one-sided affair altogether. But this aspect of how 65B certification applies qua digital evidence, that appreciation is something that I'm really looking forward to at a GSTAT level, because certainly that appreciation is not happening at the first appellate level. And I think the last point is, in terms of, 60 to 70% notices are of systemic mismatches. A lot of AI engines are being used, and every single mismatch is being flagged as a potential case of ITC fraud. Right? Many of us are handling those sort of cases. So I think, of course, the Sterling Wilson judgment throws a lot of light, and we take a lot of optimism from that judgment, that just because there is a mismatch, What is the evidentiary value of it? Does it corroborate with other evidence in terms of intentional evasion, etc.? Second is the retraction of statements. Often, I mean, we know in high-pitched investigations, anti-evasion or DGGI would force statements that come out of forced confessions. Even if you 3-4 days later file a retraction, that is not given credence to at the first appellate level. There is a settled jurisprudence under law of evidence, under criminal laws, in terms of how to deal with retraction, when is retraction credible, when it is not credible. I think all of these aspects we will really look forward to the GSTAT to set standards for the first appellate authority, for the adjudication authorities to also follow. So I think, yeah, these are some of the aspects that we.
Sorry, if I may just ask, and to you, Mayank sir. So you have been in the courts and now being in GSTAT. So as Sudipta, I think, very nicely explained all these intricacies. How do you see in GSTAT these would flow?
Sir, definitely we will follow the principle of natural justice. As well, you rightly said that the cross-examination is the spirit of the main backbone of the any statement. If some statement is not controverted with the cross-examination, it is had no value. Because through cross-examination, you can veracity the genuineness of the statement. And since a judicial member is a part of the bench and having a technical member, I think definitely we will go for the judicial principles to be followed in the GST.
Even CSTAT recently in several cases have relied on the same arguments that without cross-examination, those.
Absolutely. Now moving on to Yogesh ji. Timelines is again a very critical concept under the GSTAT appeals. So what are the key dispute areas which you are practically facing related to the timelines, condonation? Further, say if there is any technical issue on the portal while filing appeals, how the taxpayer should go about it? Is there any possibility wherein this timeline of 3 months and condonation of 3 months can be extended? So your views on the same.
Yeah, thanks, Tushar. So I think as far as where the order in appeal is uploaded on the portal, there is no technical glitch, everything is smooth. But in one of the detention cases we have faced, that usually what happens in vehicle detention cases, that the mobile squad unit of the department intercepts a vehicle and creates a temporary ID. Okay, so all the the documents, MOVs, show cause notices, orders are uploaded on that temporary ID. Now what happens that GSTAT also has a linkage of that temporary ID option on its portal. But what we are facing is that when that temporary ID was created by the mobile squad unit, let's say our authorized signatory was Mr. Suresh. Now he has left the organization and his number was there, his email was there. Now we are going to GSTAT portal using that temporary ID option, but the OTPs are not coming. Now we have also amended the authorized signatory in the temporary ID, but still the OTPs are not coming. So that is one of the technical challenges we are facing. We are not sure whether we can continue with the temporary ID or go to the normal ID and then file a manual order there. So that is one issue we are facing. Other are with respect to manual orders, because when it comes to timelines, the major issue sometimes comes when the order was communicated. So when it comes to the portal, of course, when it is uploaded on the portal, then again there are two line of disputes, whether the provision with respect to service of orders and notices, whether it has to be read sequentially or it has to be read mutually exclusively. That if one mode of service is given, then that's enough. But sometimes taxpayers are getting their orders uploaded on the portal, but they're not getting any email. Okay, so there is one high court which says no, there must be an email. There is one high court which says no, email is not necessary once the order is uploaded on the portal. So I think these type of disputes will surely come to GSTAT, whether in these circumstances the limitation can be relaxed. But with respect to condonation, I personally feel that, of course, when the law is drafted, it is a finality subject to the interpretation by the courts. But there is some anomaly left in section 112, subsection 6, which says that for condonation period, it says GST-80 may admit an appeal within 3 months. So I would also like Shri Manchi's thoughts on this expression that GST-80 may admit an appeal within 3 months from the date of expiry of original 3 months. But when it comes to application, in case of cross objection, it says may permit filing an appeal within 45 days. Now when it comes to filing of appeal, it says may admit within 3 months. So that means the entire process of admission of appeal must complete within 3 months. Now this expression may admit an appeal within 3 months is little bit tricky because the intention cannot be assumed that the entire process of admission of the appeal, that first it is filed, let's say the person has filed let's say within 2 months after the expiry, and then there were defects, 15 days to rectify those defects, and then the matter went to tribunal and it feels that okay, we admit that appeal. Now the entire appeal is, let's say, not admitted within 3 months. Then what happens in that case? But the appeal was filed within, let's say, 2 months after the expiry. So that I feel a little bit anomaly in the provision. At the same time, for cross objection application, it says may permit an application within 45 days. So filing of cross objection application is 45 days, but filing of, after condonation filing is not actually 3 months. The admission has to happen in 3 months. So that I feel is a disconnect between the cross objection application and the appeal.
I think good point raised. Rajiv ji will be taking care of this point and answering this. Now, moving on to Deepak. There are lots of cases related to investigations by DGGI. Now, practically what happens is that in case of a DGGI investigation, the demand pertains to multiple states. So the adjudication authority issues a single detailed order, whereas you have multiple DRC 07 for different states. Even at the first appeal level, there is a single detailed appellate order, and then you have APL 04 for different states. Simultaneously, penalties are imposed on directors, employees, etc. So in such a scenario, can you just guide on number of appeals that has to be filed and what practical issues you have been facing similar to these issues regarding number of appeals that has to be filed?
Right. So I think for, let us say, in a show cause notice or in an order, if there is a penalty on a director or a third party, therein the rules also are clear that you have to file a separate appeal for each party. In fact, for that matter, the rules are clear that as many order in originals are there, that many appeals have to be filed. So I think for that, the answer is relatively clear. Where the confusion comes, and it was also there for the first appellate, was in case of DGGI, a valid example wherein there may be, let us say, 10 registrations which are covered, but there will be a detailed single order in original. Why? Because there was the concept of common adjudicating authority, which is there in the GST provisions. Now, the confusion initially was for the first appellate authority, a circular was issued saying whosoever was the common adjudicating authority, that would be basis that you decide the common appellate authority, go there. So only one appeal. Taking that logic further, while the circular does not cover GSTAT, I'll take the logic further to say from the appellate authority order also, a common GST appeal would suffice. You need not have 10 appeals in this case. That is, I'll say, a legal answer which is there. I'll just complete on one practical point. Recently, what we saw in filing the appeals was in this case, there were also amounts coming registration-wise in the liability ledger. And we did not want to take a risk that, okay, if my appeal is filed for the pre-deposit, I'll have to go vis-a-vis the registration-wise or the liability-wise. So not taking any risk, we ended up filing as many appeals as were there on the portal. But that was more of a cautious approach being there. But yes, we have replicated effectively one appeal. We'll be taking the matter, and we have filed those 10 appeals also in the same jurisdiction with the same GSTAT. We have not filed it across India. We have filed it at the same location, but so as to avoid the confusion of pre-deposit and recovery. We have filed as many appeals as of the orders which are coming on the portal. So that was more of a practical approach.
Like you mentioned that there is clarification for the appellate authority. So we saw the DRC 07s were being issued for each state as well. Say in your instance you mentioned 10. So your appellate authority is a common authority. And for a fact that the GSTAT in this case would also be the one which has jurisdiction in logic, in the consequence of the same logic, it will be the GSTAT which has jurisdiction over the appellate authority. In those cases, we used to just file a letter before each of the DRC, against each of the DRC 07s, that a common appeal is being preferred against the common adjudication order. Is it not more practical to continue with a similar approach? Because it only increases the compliance for a taxpayer, because more or less all your DGI matters are heavy duty matters. They are not matters where your appeals are going to finish in 100 pages. The likelihood of multiple issues involved, huge stakes involved. So everything will have to be replicated for all the GSTNs and then for all the years as well. So is it not practical to just file a letter saying that we filed the appeal? Please correlate thereto like we did for the appellate authority.
So again, being high duty matters, we erred in favor of caution. What we also realized was because these pre-deposits would have to be registration-wise. Earlier, the benefit which we were getting was that for pre-deposit, you could have a single pre-deposit and others could have been zero, or you could have increased or decreased that. Now, strictly going by the compliance, and I've always believed that in GST portal does play a part, that is where with these highest values, we did not want to take a risk that a state, let us say there's a state down south, wherein while I filed a letter, he says there's no appeal, I come for a recovery of this amount. Rather than being in the situation, we followed this approach, again a cautious approach. The letter, we also did it in a couple of cases, but in most of the cases now we have been filing, even for the first appellate, we have been filing an appeal, and in that we reproduce the entire appeal which we are taking to the common appellate authority, saying that they would be deciding it, but we are doing it for compliance.
Perfectly fine. So effectively there are two approaches. One is the practical approach and second is the conservative approach. We will also seek guidance on this issue from our honorable members also. Now moving on. Shagun, pre-deposit is one of the important aspects of GSTAT. Can you explain the statutory framework related to pre-deposit and some of the common issues which taxpayers are facing? Like for example, if they have paid the tax during the investigation stage only, either under protest or otherwise, how it can get adjusted, or for first appeal they have paid 10% of the pre-deposit. Luckily, in the appellate order you got 90% of the relief. Now when you are filing appeal for the remaining 10%, do you require to again pre-deposit? So practical issues being faced by the taxpayers at ground level.
So pre-deposit is one of the most mandatory and one of the most contentious issues amongst tax litigation. Having said that, the basic pre-deposit for every level that we have, the first appellate and then the GSTAT is 10%. So 10 and then another 10. This is a distinction which we saw from the earlier regime to this regime, that your appeal to the GSTAT mandates an additional 10% over and above what was paid under 107, which was before the first appellate authority. Meaning thereby that by the time you reach the GSTAT, you have to have paid a mandatory deposit of 20% of the total tax amount. Where your order pertains only to imposition of a penalty without a tax amount involved, after 2025 October, there is a mandatory pre-deposit of 10% of the penalty itself. This provision has been introduced in both your appellate authority as well as your GSTAT appeals. So there again, you result in a 20% payment of a penalty as well by the time you reach the GSTAT. So far as your issues are concerned regarding how do you deal with the pre-deposit, say for instance, while you've paid under investigation, you've paid under protest, or when your appellate authority has been gracious enough to drop certain demands. For the first part, I believe that there has already been an advisory which was issued back in April 2026, where it was clarified that if there is any amount which the assessee has paid during a proceeding, that could be during the course of the investigation or say at the time when the show cause notice is being issued, that mandatorily has to be acknowledged towards the pre-deposit. One cannot do away, the department cannot do away with it as a voluntary payment. It cannot treat it as an admission of liability. And if the assessee chooses to contest the demand, then that amount has to be acknowledged towards a pre-deposit. The entire mechanism has also been put forth. If the amount has been paid via DRC 03, it can be traced through DRC 03A and thereby attached to the liability. Therefore, it gets traced in the entire portal. And another issue which we saw is that one of the issues which the department has also clarified, that when an amount was paid during investigation, that amount was completely reduced from the demand order. there was an ambiguity there that is the remaining amount challenged or the entire amount is challenged. The department has sought for the assessees to approach their authorities and seek amendment in the orders itself, so that the entire amount should be captured and the assessee should be given the right to contest the entire amount and adjust the amount paid under protest towards the pre-deposit itself. So at whatever stage, if any pre-deposit has been made and it captures, or any payment has been made and it captures your pre-deposit amount, that recourse has to be taken by the taxpayer to get that adjustment and get that acknowledgement. And so far as the second question, as you had put forth, I believe that still is a grey area. So 107, which is the appeal before the appellate authority, requires you to pay 10% of the pre-deposit amount. Now in a situation where, say, your total demand was for, say, 1 crore, and I paid 1 lakh towards, 10 lakhs towards my pre-deposit. Ultimately, I saw my demand get dropped by 80 lakhs and now my existing deposit is only 20 lakhs. To go to the GSTAT, the provision says that the pre-deposit has to be 10% in addition to the payment made under 107. If I read it strictly, then in addition would mean that for my appeal before GSTAT, I will land up paying 10, which was 107. And for the 20 again, I pay 10%. So another 2, I'm paying 12 lakhs for a disputed amount of 20 lakhs, which is almost, it's 60% of the demand amount. Whereas logic would say that your 10 lakhs already covers far more than the 20%, therefore it should not be required. But the strict reading of the word in addition to could result in defect notices being issued, could result in a completely different tangent of litigation as to how the provision of pre-deposit has to be read. Is it supposed to be read strictly or equitably?
So just to add here, in the last part, practically some of the authorities have started granting refund of the excess pre-deposit.
Taking this discussion of pre-deposit ahead, Avinash sir. Now, pre-deposit in respect of appeals involving only penalty, effective 1st October 2025 has been introduced. Now, say I have filed the first appeal before 1st October 2025. There was no pre-deposit at that time. Now, I am going to the GSTAT. Am I required to pay 20% of the pre-deposit, or I am required to pay only 10% because it is in addition? Or can I take some litigative stand that no pre-deposit is required, some kind, because it pertains to the whole period, some litigative stand we have been taking?
Straight answer is 10%. I will be required to pay 10%, but now, so far as litigative steps are concerned, it again depends on the appetite of the taxpayer or the litigant. If I have been given an opportunity, then certainly I will litigate that in any order or any period which is prior to 1st October 2025, there is no requirement of any pre-deposit. When it is only penalty cases, it falls into the proviso which has been recently introduced. So there are a number of judgments of Supreme Court, right from 1953 till today. Many judgments have been followed, and religiously now the courts are also taking a view. Recently Madras High Court has taken a view in one of the matters wherein huge penalty was there and they have waived the entire penalty. So I'm not talking about the waiver, I'm talking about the legal right. Whether legally I am bound to pay that pre-deposit when my right of statutory appeal was already vested in me before 1st October 2025. So again, this is a subjective question, but the answer would be yes, 10% will have to be paid. If I have the appetite to litigate, then I will not pay. It all depends on the amount involved also.
Or either I don't have money, then I will litigate.
Yeah, it depends on the amount, because 1,000 crore the amount if it is involved in the penalty, because I have seen the orders wherein multiple clauses of section 122 is being invoked. Right. 122, 2, 7, 10, 14, 17, and then 10 crores penalty is made 100 crores. So right. In all that situation, I will not be able to pay that 10% of the 100 crores. So in that case, I'll go and fight.
Sure, sir. Moving on, sir, is there any concept of waiver of pre-deposit under GST? Though we have seen there are some tribunal judgments in exceptional situations have granted relief. So there is a very small ray of hope that at least in 2, 3, 4 situations we have got that relief from the High Court. So how practically at ground level it is feasible, at least in those cases where there is actually a very genuine financial hardship?
So I think let's break it down into two. I don't think, subject to correction, sir, GSTAT being the creature of the statute, whether GSTAT using its inherent power can condone or waive pre-deposit, I have my doubts. Using inherent power as a tribunal, I think it can, again sir, subject to correction, it can stagger it or make it in installment. Those sort of benefits probably falls within inherent power. Complete waiver probably does not. High courts under 226 or 227 I think can be approached. High courts have been very, very reluctant. I speak from experience, having lost many such pleas. But only 1 or 2 cases where very strong financial hardship, High Court, Delhi High Court, I think in one case allowed that, okay, it's a rare and deserving case, and that's the filter. Rare and deserving cases they can grant. Of course, if you don't have money, I mean, I have just lost the biggest indirect tax matter ever for online gaming. So around 2.5 lakh crores, and I think many of my clients will file for insolvency. so for them, I'm sure I'll be approaching quite a few high courts seeking the same prayer. But yes, the filter remains. I think that rare and deserving cases. What is deserving, I think, will remain to be seen, fact specific, etc. Since one question or maybe a request from many of us. I think one of the biggest gray area today, qua pre-deposit, is can I use my credit ledger to pay pre-deposit? I know, I mean, we are aware of the judgments in and around for and against. There's the Supreme Court judgment in Yasho for first appeal. Does it, I mean, logically it should extend, but does it extend, etc. I'm not putting you on a spot and asking an answer here, but if a guidance formally through an office order could be issued, I think a lot of unnecessary debate one way or the other and litigation could be avoided, because this, I think, is a burning issue, because many SSEs have massive amounts of credit. And also the sub question is, if the answer is yes, is it yes for both RCM as well as forward charge disputes, or is it only for forward charge disputes? I think if a clarity, and maybe if required from PhD chambers, we could file a formal representation. But if that clarity could be issued, that would be really, really helpful, sir.
So, in addition to pre-deposit through ITC, I have a question with respect to whether pre-deposit can be adjusted through my bank guarantee, because in detention cases, I have an option of bank guarantee. So if I pay 200% penalty as a bank guarantee, my goods or vehicle will be released, and then the provision says you have to pay additional 25% pre-deposit for challenge. So 100% of my amount, because bank guarantee is not like a service, they actually hold that amount to that extent. So my amount of 100% of bank guarantee is already held by a bank in the name of the department, and then they are asking additional 25% as pre-deposit. So can bank guarantee be used towards that pre-deposit? So that is also a challenge.
Sir, what we will do is that, since pre-deposit is one of the major area for any taxpayer, we will collate all these issues and formally submit your representation to your good self through PhD. Seeking some... Yes, absolutely, sir.
Just two things. Sudipta ji has said one thing, so I was just apprehending, because the law says no appeal can be filed unless pre-deposit is paid.
Right.
So if the appeal cannot be filed, it will not go to GSTAT, and GSTAT will not be able to waive. That is one apprehension that I have in mind. So the only option remains is 226. Second thing, the issue of credit ledger. Supreme Court is already dealing with this issue, and I'll give one example because I am part of that group.
Right.
So in one of the cases where Patna High Court has taken a call that credit ledger cannot be used, so the entire amount was recovered of Flipkart. The entire amount was recovered. Court has taken a view that over and above 10%, whatever was recovered needs to be refunded back. So therefore, this gives a signal that credit can be used, and Supreme Court also has a view. Now we'll have to, because it is sub judice, we'll have to wait and watch.
Absolutely. Now, before we conclude, I request each of the panelists for their closing remarks to explain or share their valuable insight or learning they have gathered during their professional journey of dealing with all these appellate cases, etc. Starting from Yogesh ji.
So, So the best learning which I have got while presenting before a tribunal is that when you have a complex case, there must be a proper synopsis which you present before a bench, whether 2-page, 3-page synopsis to explain that this is the issue in a very simple manner. Now in the GST law also, you must all be receiving orders, order in original and appeal, where you have 20 points 25 points, because all those were initially an AI generated automated orders and they made 25 points. Now filing an appeal before the tribunal on those 25 points, how will you be able to explain to the bench each and every point with each and every fact and then the merits from a legal perspective also? So how to draft your appeal that you have covered the factual part, you have covered the legal part, and then how to present that before the court, before the tribunal. That is very, very important, I think, to have successful journey before the GSTAT. So presenting in a very crisp and precise manner and explaining the tribunal in a very like a concise manner would take us to a long way, I think so.
So I think mine would be, and I spoke a lot about facts, and the reason I spoke a lot about facts because I see that as a very, very commonly repeated mistake. Just because a show cause notice records 100 points of facts against you does not mean you need to accept even one of them. It is the burden of the investigating authority to prove those facts against you. Often what we end up doing in defense is we fight on law. I think if one thing I would suggest, it is that fight on facts. Law is more or less settled. Law is there. Fight on facts, whether it is digital evidence, whether it is, do not be lackadaisical about cross-examination. Even if it's a statement from, say, someone who worked with you, someone who is your employee, it does not necessarily need to be adverse or a sort of adversarial process. It can be a clarificatory process also. So I think that factual part of it, that test every piece of evidence against you, I think is one aspect. Second is, I think a lot of appeals will come in terms of reconciliation issues, right? We can tend to get mired in numbers. What we need to do is probably, wherever possible, need to see, is there a legal issue or a question of law that is arising out of this reconciliation? Assuming there is a mismatch, does that per se justify an invocation of Section 74 intentional evasion? Assuming there is a mismatch, does that per se conclude a liability against you? I think that is how we will need to frame the question before an authority, a second appellate authority like GSTAT, not merely reduce it or keep it at the level of a factual discrepancy. So I think, yeah, that's the thing.
Thank you, thank you.
So I'll take it forward, I think, and because in the previous session also we discussed that legal point can be taken at any forum. I think the suggestion, especially for GSTAT, would be take all the legal points. And again, that should be there from the starting, but at least at GSTAT that would become very, very critical. So just sharing an example, there is a refund order which we won in the first appellate, and we are filing an appeal. And the department has raised a point. So we are starting from the basic point that whether the department could have taken a new ground which was not there in the show cause notice. Again, I believe several jurisdiction points, be it on timelines. I think Sudipta gave brilliant examples on evidence of what all points have been taken, whether those were there. The procedures also are very important. So I think we do focus a lot on merits, which is definitely very important, but all these procedural points, jurisdictional points also, sometimes make a case for you.
Continuing therefrom, I think like how it is in most of litigation, the way you articulate a matter really matters. GST is, I believe, 30% law, 70% numbers, and especially litigation of GST. We have so many cases pertaining to 2A3B, 1.3B. It can get extremely mundane for a bench of two to hear you for 2 hours as to why your balance sheets and your 9C and 9 are matching or not matching. It's not a case where you're sitting in the chambers of your adjudicating authority and you can show the sheet, you have that much time. So the way you present your case is going to extremely be important, and it's going to decipher its fate. So there has to be some form and formatics that every person, every advocate, every CA will have to develop over a course of time, how to present these forms of cases. And of course, every case has to be judged in its own sense. Like Sir had mentioned, it's not important that the merits of the cases are going to make you meritorious there. You have to decipher what is the best case for your assessee to come out of that and to how you rescue that particular taxpayer find all sources and argue all of them. It's not important that only reconciling is your way out. 73, 74, man procedure, assessment, scrutiny, everything, your entire act has given you so many options to attack a particular show cause notice. They're numerous. So please explore everything that is available.
I'll say only one thing. This is a new battlefield for all of us, and we'll have to be prepared. And prepared in multiple ways. I'll just give one example. Recently, on 22nd of May, Honorable Supreme Court, rightly said by Sudipta ji again, that the digital evidences, electronic evidences are going to create a lot of help to us while arguing the matters before tribunals. So there is a judgment of Pune Bar Association recently pronounced by Honorable Supreme Court, wherein they have said that hash value is mandatory for electronic evidences. So just on this point, I think majority of the departmental issues will go, because now it is mandatory, and in none of the matters there is a certification which has been taken of the hash value. Just with this is one example. There are a lot of such things which we need to learn and then start appearing before the courts. Thank you.
Thank you.
Lighter vein on the hash value. So because I keep raising these points, DGGI Gurgaon recently had to send a pen drive, and he said that I had sent it through a runner, and they said you need to send a lawyer for witnessing this thing, because I know you will go and challenge that the hash value was not taken. You will try to exclude it from evidence.
Thank you all the panelists. And before we conclude this session, sir, may I request your final concluding remarks and final thoughts as someone who's a part of this institution making process? Any message to the taxpayers and professionals?
Sir, the duty of a judge is based upon a principle that neer shir viveke, दूध का दूध पानी का पानी कर देना. And I am sure and I am confident that the judicial member as well as the technical member of the GSTAT, principal bench as well as the state benches shall impart justice fairly, truly and true justice. And we are in the beginning of the decision making process. अभी benches हमारी functional होंगी धीरे धीरे. So I am sure that we will deliver a good judgment, and we will try to say, we can't satisfy everyone, but we will try to satisfy according to the principle of the law and justice. Thank you, sir.
Thank you so much, sir, and thank you so much all the esteemed speakers, distinguished experts here for your very valuable session we had just now. Before we start, I would like to just present a small memento to our session chair as a token of our gratitude. I'll request Tusharji. I'll also request our chair, please, if you can join us on the stage. Ashok Batra ji, please join us. Please present a memento. I'll request Shivamji also, you can join us on the stage so that we can present a small memento to our session chair. Thank you so much, sir. Thank you so much. Our gratitude for sparing time with us and taking up all very important questions that solve so many problems with us. So I'll also like to present a small plant to all our speakers. Please. I request to please present a small to all our distinguished speakers, please. May I have a big round of applause for all the experts. Please present one to Sudipta ji also. May I have, please continue giving a big round of applause to each one of them, please. I'll also request to present one to Sudipta ji and to Yogesh ji, please. Thank you so much. Thank you so much for sparing time. I know it's a Saturday, but I think this is the only day when we can have you here, because otherwise you all are very busy with your schedule. Thank you so much for being with us. And very soon we will start the new panel. I'll request you to please join us there, please. Oh, group photograph. Sorry, I just missed it. We can have a group photograph. That's so much needed for our memories and further taking it over. Please. Thank you so much. Our next session is about the drafting and filing of GSTAT appeals, and our session chair is already here since morning. I'll request Rajiv Kapoor ji, he's a technical member and he's the session chairman. So I'll request him to please join us on the stage. In the meanwhile, we'll just put up the nameplates, but I'll request you to please join us on the stage. I'll request Kapil Sharma ji from Elixir. I'll request Shivam Mehta ji. He's a co-chair of an Indirect Tax Committee of PhD Chamber of Commerce, and also he'll be moderating this session. I'll request Saurabh Chaudhary from Taxcraft and Pawan Arora ji from Athena Law. Please join us on the stage. Prerna Chopra from SBC Legal. Prerna ji, please come. So I'll now request Shivam ji to please moderate the panel.
First of all, a very good afternoon once again. I think I'll start with the thanks to Rajiv ji for taking time from his busy schedule and coming here to share his thoughts and provide answers to some of the questions which, as a moderator, I'm going to put. And also, all of you are welcome to ask any kind of question to Rajiv ji or all my learned panelists around here. Now, before I start the session, I think last session we were deliberating about various issues. We were talking about additional evidence, grounds. I think what my takeaway of the previous session was, what I think each one of them echoed was, don't shy away from taking any ground. Forget additional evidence for a moment. Madam asked about additional ground. Whatever, how much stupid you feel the ground is, let judge should decide. Our problem is we become judge of our own matter. And then we decide, no, we will not take this ground, people will laugh. You never know. A most foolish ground can actually be your most successful argument in the court. So don't even think while taking any ground, primary, alternative, should not be contradictory, but take all the grounds available under the sun when you are litigating the matter. Why I am saying so is, you are now at the GSTAT level. That's going to be the final fact-finding authority. The success or failure of the case of your case or your client case will depend upon what ultimately GSTAT decides. And if you look at the history in the past, I think each one of you will vouch for it, a CSTAT order becomes a stepping stone. It can be challenged in the High Court, it can be challenged in the Supreme Court, but ultimately those higher courts, they are more busy than the CSTAT or the GSTAT. If we were talking about number of cases of 5 lakh plus in GSTAT, if we have already waited for 8 years for GSTAT to function, we can wait for another 2-3 years for these cases to get resolved. At least I am not in a hurry. I am certainly not in a hurry. But if you go to the High Court, the pendency goes like anything, roof high. And Supreme Court, they will not give you a minute. They will not even listen to you for a few seconds when it comes to admission. So this bench has to be your best shot. Cannot be a second best shot at this level. With this, I will start with our session chair, Rajiv Kapoor ji, just to, according to you, once an appeal is filed, what are the essential elements which has to be kept in mind? And what are the common mistakes you have seen in the courts or you have seen otherwise in your journey as a in the department, he has been Commissioner Service Tax. I appeared before him. He don't remember because that was in the COVID period and we were virtually, he was in office, I was at home. You were attending initially when the first lockdown got over. Department officer, those who can recall, were asked to come to the office and attend the hearing virtually. So as per your experience, sir, what are the common mistakes and what are the strong points an appeal should have to, make it successful and help you to deliver? Jaise President Saab ne kaha, Nyay. What are your one plus point and minus point that way?
Good afternoon. First of all, my sincere thanks to PhD Chamber of Commerce and Industry for giving this opportunity to me to come here and interact with you. The entire team, Shim, you were there, Tushar was there, Madam Babita was there, then I had opportunity to meet Mr. Batra also. So, first of all, as he already said, I am from the Indian Revenue Services, so my background has been on the departmental side. So, more on the executive action. A large part of my career has been in investigation intelligence in the commissionaires. I was fortunately member of the GST Law Committee for more than 5 years. That gave a lot of exposure to the drafting part. So I think I'll be here more to listen than to suggest, because people are there who are expert in the field of how to draft, well to draft. So, but from my experience working right from the beginning as assistant, I started my career in Delhi, in fact, then worked for about 15 years in Maharashtra, 10 years in Mumbai, 5 years in Pune, as a quasi-judicial authority, as ACDC or as joint additioner or commissioner, or as a principal commissioner. You hear the other side, then pass the order. Of course, that is not, I would say, related to the court part of it. But definitely, as I worked in First Appellate Authority in Customs in Mumbai. So actually what I would simply put it is, the three elements which are very important is, one is clarity, I would say. Second is the precision. And third, I would say, is the legal discipline. So in clarity, I would say, when you are making an appeal or you are presenting an appeal, you should be very clear in your mind or in your appeal, what are the facts involved, what are the contraventions involved, what are the points on which you are seeking the order. Those should be very clear. And at the same time, I said, those should be crisp also. Many times I have seen there are long pages. In fact, sometimes I remember in service tax, I would see, with all the due regards, I have a lot of regard for chartered accountants. When they started coming in service tax in a big way in 2008 onwards. So what you would typically found was a difference between an appeal prepared by an advocate and by a chartered accountant. Is that when that appeal is coming through a law firm, you will have a lot of deliberation on the issues and what a legal part of it. Whereas when you find an appeal coming from a chartered accountant, typically you will find a lot of these are case laws and data and all that stuff. So what I would sometimes feel, of course, case laws are very important. They know, but equally important is how well you contest the issue. First you contest the issue, and then case laws are there to back you. You cannot say that simply the case laws are there, so therefore, you don't even argue the basic issues involved. So these are, I think, very important issues. Of course, over the years, as service tax evolved and GST came, I have seen excellent work. In fact, I have interacted a lot with ICI. When the GST started, I was a master trainer, first master trainer among the first lot. And we used to interact a lot with ICI in Mumbai. And Pune also I interacted a lot. And I found real quality work coming because these are like, in the first session we were interacting, a lot of these issues were coming from the balance sheet and ST3 and your balance sheet data not compiling, the difference between what is called TDS data. So a lot of show cause were issued based on data which was taken from the CBDT server and this thing. And later on that scheme also came, Sabka Vishwas, so a lot of issues were settled also in that. So like this now again, I can slightly share with you, because this issue came up in the first session also, that this 2A, 3B, 1, 3B issues, because now again, this entire thing is, data is getting captured, and that we are finding that the initial phase, there is a huge mismatch. There could be many reasons, like for example, a lot of this initial year data in 2A and 3B could be because some parts were not getting captured in 2A. So those missing now, then the clarification came, if the person is coming with that, kindly resolve it. So I'm sure with this now, a precisely built, like one of the panelists was very excellently mentioning, when you have this kind of issues, then you are going there for, that my entire case is on reconciliation. So prepare a good reconciliation sheet so that you can, whatever time is there, you can satisfy the bench. Yes, this was the issue. This my 2A difference has come because this much is import of this thing. This is on the reverse charge. This is, which was, whatever was not captured this. So therefore my data is comparing. So I'm sure bench would not like to remand unnecessarily if my reconciliation sheet is very good. So bench would like to decide there and then, as Honorable President Sir has very categorically mentioned, that his endeavor and the entire all benches is not to put you back in the loop unnecessarily. If the decision can be given, we will try our best to give the decision. But then please come up with excellently made. Similarly, for example, if you have some other evidence to support, like many cases you will find Sunwet credit, whether that was registration was cancelled or for whatever reasons. I mean, whatever evidence you are generating, please do that. Don't simply say that, okay, this is merely not matching, so you have to allow me the credit. If you can back it up with a good evidence, so please bring that in your appeal. I'm sure that will make a lot of difference, easy for the bench to understand the issues.
Thank you, sir. You have very precisely put across the point as to what as a bench is expecting from the professionals. On that small part which you said, CA and a lawyer, there is always a difference. So I think 4 of us are CA and a lawyer both. So just to give a right perspective, I did my CA and a law both. So I know as a CA, if I have to secure good marks, my answer sheet should be heavy. Those who are CAs will vouch for it. For an advocate, I think the journey has been slightly different because they are taught in the court how to present themselves in the now 5-year colleges. They train you how to present the matter. So I think when a CA comes before you, please have a heart for him because this is how he has been brought.
I see very clearly that over the years, I have seen excellent work being done by chartered accountants, and the way their appeals are coming is really marvelous. I just said jokingly initially when it started, when the CS started coming.
Sir, I think what you are saying is now CAs are also learned how to, or thanks to you that you have been a part of ICI on that front. Now coming to the panelist, I'll start with the only lady on the panel. So, Prerna, what do you think? Is it this litigation in GSTAT? Is it a drafting game, or as per you, it's a litigation strategy which has to be worked out? Because prior to that, it's a reply or a first appeal. Do you think there is a role of some strategy also which has to be placed here?
Broadly speaking, when you come to GSTAT, it's a blend of both litigation and strategy. Why do I say it's a blend of it's a blend of drafting and litigation is on the fact that drafting is very important because that's how you communicate your strategy to the tribunal. And why I say strategy at the same time is that it is very important that at the lower level, whatever you've submitted, You submit it before the GSTAT tribunal also. So therefore, your drafting skills will reflect your strategy. And in case there's an unfavorable order, you have to put your grounds while you're drafting it in such a manner that you have a room to go to the High Court or a Supreme Court, as the case may be. So therefore, you need to be very sure of what you're drafting, and as you rightly pointed out, even the silliest ground should also be there in your drafting. And I can tell you in a real-time experience, we were dealing with one of the order yesterday, and I was reviewing the appeal. It was written 25% of the pre-deposit on the face of the order. Now, how does the 25% come? This clearly shows, the matter has been handled very carelessly by the authority. They said the allegation was with respect to that, you have not filed, the vendor has not filed the GSTR 3B return, but is reflecting into it. But the observation in the order is that, you have not, it is not getting reflected in your 2A. Now, you take a screenshots of by putting the GSTN of the vendors, you can see that they have filed one, right? So I know this is one of the most silliest ground, but you don't know how sometimes it may turn around and you may get a remand back order also from the tribunal. So as I said, drafting is very important, but at the same time, you need to know what is your strategy going forward. Put as much as grounds you can, even though it is as silliest as possible. So that's my take on this.
Thanks, Prerna. Coming to you, Saurabh. I mean, now she has made it very clear. I mean, there is some kind of strategy. As per you, so generally we have seen when it's nobody's mistake, but everybody has a different approach. Generally we have seen when first appeal is filed, it is treated as a continuation of adjudication order. Now we are going to second appeal. And till first appeal, usually we don't have any opposition. Here there will be a opposition also. Do you think there should be a change in the mindset now when you are going for a second appeal before the tribunal?
Sure, thanks. So in case of adjudication or first appellate authority and vis-a-vis GSTAT, so what happens is the adjudication authorities or the audit or the first appellate authorities, these people are primarily from the revenue and they are bound by certain circulars, they are bound by internal guidelines. So that is one thing. So in case of GSTAT, it is pretty much clear that, GSTAT can operate independently and it is not bound by what internal guidelines or what circular states. So that is one very much critical factor. Also in terms of adjudication or audit, what happens is adjudication and audit, they are very time bound because the authorities, they might audit might be for 5-6 years wherein they have to ensure that the audit, adjudication and the order is done in a time bound manner wherein you don't have option to present your case as like you would want to, because you are more focused on collation of data, you are more focused on collation of proof documents and explaining the reconciliations to the authorities. So in this case, this is taking a step back, deciding what your litigation strategy should look like, where you want to and you don't need to blindly appeal everything. You decide what what is the benefit or what is the relief that you are seeking, and then you formulate, draft a strategy and your arguments, your submissions and your proof. And also one critical thing here it is that should be noted that GSTAT is a final fact finding authority. So at each level it becomes difficult to submit your additional evidence, but beyond GSTAT it won't be it's rather impossible to submit your additional evidences. So it should be that should also be taken into consideration. And appeal, GSTAT appeal should be treated very differently. And also one thing, in case of Sterling Wilson, we saw that the section 74 and section 73 distinction was clearly held. So while we are dealing with the with first level appellate authorities, at times that relief that in case there is no fraud or there is no misrepresentation of facts or anything on those lines, even in that case section 74 is invoked and extended period of limitation and extended penalties are invoked. So that is also something which I believe a right strategy will allow us to get better results at GSTAT.
Good. Thanks for your input. Now moving to Kapil. So while we are answering this question, let's don't focus on 2A 3B mismatch. Uska to jo hona hai. Let's talk about legal issues here. Now Kapil, coming to you, you have an adverse order in hand. What are the key things you look at? and this order is not 2A, 3B, it's a proper legal issue. What will you look at? What are the key things you will find? What is missing? What you want to add? If your thoughts on that.
So every person has a different perspective to read an order. Generally, sir, there are two parts to an order. One is the operative part and the other is the background. When you come to the order, as far as my individual experience is concerned, you go to the operative part, refer the findings first, read the conclusion in consonance and finding, and then try and read backward to see all the submissions had been factored or not. That's my individual approach to it. How do you read an order? Sir, with respect to the operative part of order, what I have observed is that there is a certain manner and a format in which orders are issued. They will have a background, they will have the legal position, then they will put the arguments, and then they will give the finding and then the conclusion. That's the general frame of an order, sir. So, sir, first part is generally repetition of the show cause and your submission which goes behind it. The critical part, which is the operative part I was referring to, relates to the finding. Sir, my observation with respect to findings are, you may have given 10 sets of grounds, your preposition, evidence, and supporting case laws along with circulars. The smallest part in an order generally is the finding part, which should be the most elaborative part, sir. That's my experience, because finding is what your view with respect to the submission, sitting on a judicial chair to decide whether it is the adverse or the drop proceeding or the confirmation. Findings are to maintain the brevity also, at least with respect to your submission, the findings should give an para to your submission stating why they don't agree. A mere disclosure of a line stating that we do not agree with the submission made by SSE on following grounds is not a speaking order, sir, to my concern. Sir, it is merely a yes or a no, whereas finding is supposed to spell out as to what you have relied is correct or incorrect. And in an adverse order, you have disagreed with the findings. So you must give a logic to why you have disagreed, sir. That's the first principle I read, sir. Similarly to case law also, sir, what they say, and that's my experience, is we do not see the fact of the case applied to your case. Sir, in my experience of 20 years, I have not seen case laws, decided case law or judicial precedent will match exact fact pattern to your case, sir. It can never be, sir. You only have to take out the inference to apply to your case, or so to say ratio to apply to your case, sir. The facts were different. Sir, what fact? We are not here to decide and compare facts of a case. We are here to decide the ratio. That's how, Shivam, generally I read an order, and my personal view of making any appeal, whether it is first, second or further, each finding must have a contrary observation to your side, why it is correct, why it is not correct. That's my way.
Now I think we have an adverse order. Kapil has told us how to read it. Now let's go to the drafting. Now, Pawan, I think you are the one left waiting for the mic eagerly. He's looking at me, meri bari kab aayegi karke. So because I just skipped and I came here, so I just saw him passing on the mic and holding it tight. So मैं बोलने वाला हूँ. So Pawan, coming to you, now you have an adverse order. Now, when you are going to draft the submissions, I mean, are you going to build on that order, or it can be case to case, or you will, adopt a complete new approach while filing an appeal? How do you look at it, out of your experience in CSTAT and other courts?
So I will share the both side of it. So I think if we handle the even starting from the investigation or the audit, we keep in mind that whatever in future we are required to take up pleadings even before High Court or the Supreme Court, that should be maintained from the audit or investigation itself. So first principle should start from the basic investigation or audit itself or the show cause notice reply. So we should carry our grounds with that. but sometimes cases comes to us at an appellate stage. So I give you a real-time example that a case came to me that Commission Appeal has held that this is time-barred appeal, so he doesn't have the power to condone the delay. But when we actually see in the matter, the person who has drafted the appeal has not actually looked at the fact that when he has actually communicated, the order has been communicated to that particular person. That order has been served to him with the recovery notice, and he get to know first time only after 9 months with a recovery notice, right? But the person has drafted an appeal in such a manner that yes, there is a delay of 120 days, so may kindly condone. The Commission Appeal doesn't have the power. So we have approached the High Court. Although High Court has not commented much on the condonation, but yes, by looking that there is no opportunity, they have remanded back. They have argued, the respondent has argued that they are taking a fresh ground. So even if we are taking a fresh ground, we should give a detailed explanation, and court has accepted that fresh ground, and they have given a liberty to us that fresh ground to explain before the appellate authority also.
That's a very good point. I think on that note, I'll stop you there because I want you to give me each one of panelists. Of course, not Kapoor Saab, because one real life case which you have seen where the drafting of a ground has changed, changed the complete ball game. Pawan, you start. Now that you have a mic, why to pass it on to Prerna?
So as I given the live example, this is.
एक ही सोच के आए थे.
नहीं, एक ही सोच के आया था.
Yeah, Prerna.
So I think, as I said, the drafting, how drafting change, one live example is that, I'll tell you what, we drafted, on the merits, it was a very strong case. But sometimes, we drafted in a manner where we said that the extended period of limitation is not applicable. And actually, while this was having at the lower level, this ground was not taken. And we completely this ground, actually the way we drafted it, because it was a question of interpretation, we said that it is a question of classification. So this ground really helped us to fight, and it got into even though on the merits that was not a strong issue, but this ground actually helped us in taking away and getting the entire demand quashed. So that's thing, as I said, it's very important, drafting helps, because this was skipped at the lower level, but at appeal we had taken this ground.
Yeah. So as you said that we should take every silly grounds which is possible. So even after the Delhi High Court judgment of multiple financial years, we took a ground in the section 74 before the Goa High Court. So the matter was on the development rights. Initially, on the first day, they have accepted that okay, this matter can be heard. But when the next hearing came, they were very reluctant to accept the writ that no, we have to go to the adjudication proceedings. So then I forcefully pursue that multiple financial year. Then they again admitted that writ. So drafting and the ground should be, every possible ground should be in our petitions or the appeal we should take. So this is a real-time example which I can show.
So before I go to Saurabh, just example came just in my mind. I thought I'll share with you guys. So this was a case wherein I have done separate supply of goods, separate supply of services, raised the invoice, paid the tax. I have got good amount of advance against the supply of goods. Department has issued me a show cause notice saying that your agreements are interlinked. There is a cross-fall breach clause. Therefore, it should have been place of, so it should have been actually a works contract service. So they were asking tax to be paid on the advance. So demand was only on the interest. Okay. Is the case clear to everybody? I paid separately as goods and service. Department said it is service because there was an advance. On goods, advance pe tax nahi pay hota hai. Service pe they asked you should have paid the tax, so they computed an interest. The reply was filed by a practitioner. Order was passed. He was building argument after argument saying that it's not a works contract. When the matter came to us, we filed a first appeal. We showed him that if we agree, if we concede on a point that it's a works contract, I have paid tax on supply of goods at the time of, कब पे करते हैं? रिमूवल पे. सब सो रहे हैं क्या यहाँ पे? लंच भूख तो नहीं लग रही? I have paid the time at the removal of the goods. We should prepare the computation कि अगर आप मुझसे works contract service पे tax मांगोगे, so I have actually paid tax before time on the entire supply because major portion of the goods tax was paid at the time of removal. For works contract, time of supply is based on the events mentioned in the contract. This ground was never taken. The comparison when it went to Commissioner Appeal, he was actually surprised to see that. He said, इसका मतलब तो हमें आपको ब्याज देना चाहिए, आपसे लेना नहीं चाहिए. He said that absolutely. And that worked so well that he gave me relief on all the grounds. But that one point which was missing at the adjudication level, when the comparison was shown to the Commissioner Appeal, he really actually felt very happy that, oh, then he also said, you should have submitted this calculation at the adjudication level, sir, we were not attorneys at that time. So that's, that's a ground which has never been taken can change the, game for you completely. Now, Saurabh.
I would like to add to similar kind of things that, when you are thorough with your study of the case, you are able to identify such kind of things. So similar kind of during even reconciliation, we come across cases wherein the department considers whatever is favorable or suitable for them. They'll try to take table 8A balances for your from GSTR 9 or wherever, or in certain cases, the balances they take from GSTR 2A or 2B, they do not even match, or at times they change. So it is very critical that, at the time of the filing of return, what was the data that was available to me, and basis that when we are doing a recomputation, be it for some technical reason or whatsoever, so we were able to identify that, in a way, the assessee had actually taken less ITC in terms of Rule 36 when you compare that 20, 10, 5%. And in basis that we were able to substantiate and get the benefit during the first appellate authority.
My immediate experience by recalling goes to a case wherein the extended period of limitation was invoked. Interestingly, on a similar matter, the matter went to CSTAT in the service tax regime till 2017 and was decided. This case was from 2017 till 22, demand period was this. For the same issue, past period in service tax has been settled. On top of it, the state authorities has already conducted audit for 3 years for the SSE, namely 17-18, 18-19 and 19-20. When we got the second appeal, what we witnessed was, in the limitation 74, this was not amplified enough to demonstrate along with the reports and previous orders and proceeding that the similar matter rest settled in the previous period and the provisions are not same but completely identical to the previous case. Therefore, where is the willful misstatement or where is the fraud in this case? If at all, it is a legal issue which is decided and to your notice. On top of it, audited for 3 years. If you amplify these kind of things and put it very simplified format before the officer, sir, it really helps because they are also able to appreciate that this information was with us for so long. Why didn't you bring us to the fact, to the earlier core? So that's why what Shivam was mentioning is it depends upon how deep you want to go down. And sir, merely by putting ground, I beg to differ, grounds can be made n number of times. But what is more important for me is whether those grounds are mere assertions or are they supplemented with relevant backing to support the ground as to why they are correct. So there is a difference. I can mention 27, 28 grounds, sir. But whether effectively I am backing them up with something substantial or not is something that looks to be seen, sir.
Now, on that, I think we should go back to the member now there has been 2 views. So where to go? Of course, to the judge, right? I think this side clearly is saying we should have as many number of grounds as possible. This side, my friend Kapil has focused on the ground should be there. So, sir, coming to you, what according to you will impact most? Will it be the comprehensive coverage, putting all the grounds, or actually what Kapil said, a strong documentation? Sir.
You have put me in a very difficult situation. To be honest, I cannot take the side. There are merits in both the arguments. You know, what the comprehensive means you are putting every possible question which can be either of the help today or tomorrow when you are further going ahead in your litigation. So yes, they have a very strong point. But at the same time, coming to the left side, I would say, see, you are raising a ground. Please back it up solidly. That is the point probably he was making. Even if it is short, crisp, may not be very detailed one, I am making 20, 30, 40 grounds, but I have nothing to back up, let us say 30, 40, 50% of my grounds. On the contrary, I am making few grounds, but I have solidly backing it up, either through data or through case laws, or over, I mean, it's a legal point which I am raising. So what I would, taking a middle path, I would say is, make it architecturally sound. That is the only thing I can say. Whatever architect you are making it, so make it sound. That would be somewhere, I would say, and of course it will again vary from case to case, matter to matter. So I think it is very difficult to...
We can completely understand, sir. Batraji was mentioning there are 5,50,000 appeals. You are the technical member from Delhi. Today, you are still feeling a relaxed Saturday. After 30th June, I don't know how many Saturdays you will find it so relaxing. On the top of it, we are telling the audience, put as many grounds as possible. Padna to aap hi ko padega, sir. So I'm totally with you on that. Now coming to more on the, so we have talked about how many grounds, what grounds, etc. Now coming to Prerna, can you just give us example as to when we say multiple grounds, which one can be primary, which can be alternative? What is strong ground? What is a weak ground, which you should keep at the back, keep in my pocket, see if it is required?
Okay. So I think one thing which we need to understand, before I answer this is that we have a limited time while we appear before the tribunal, right? And please understand, the judges also have a long cause list, or at least 50 cases in a day to hear. We need to know which are the grounds which are strong. If your merits ground are strong, we should go on the merits, which is easy for an authority to understand in the simplest manner it can be, and which is backed by the documents. But if you think your procedural ground, like if it's a question of interpretation and section 74 has been invoked, that's a strong ground, please do that. Small, I would say, small errors, grounds which you have done, the officer has not appreciated this document, has not taken on record or has not commented on the certain submissions, cannot really be taken, because please understand, we have a limited time of 15-20 minutes. So you need to know which are the grounds which are strong. As I said, if your merits are strong, let's go on merits, then go on an extended period of limitation. Third, my suggestion is what grounds he said, case laws. I think case laws come always later in arguments, or even when you're explaining.
I think, Prerna, that point has been put across very clearly by the member, and considering there is short of time, I want to cover everything I have on the plate, so I have few more questions. Coming quickly to maybe Saurabh, like she is talking about primarily alternative grounds. So what is your take on that? Can you give us real examples? I mean, we are talking about so much ground. I can see audience sleeping. Can you give us a real life example which is a primary alternative?
Yeah. So basically, I think it's very verbatim that primary grounds are the grounds wherein you have most possible chance to win this case, be it because of the jurisdiction, be it because of the period of limitation, or be it on the merits. So all the grounds wherein you have a highest possibility to win the case on merits or limitation or jurisdiction and likewise, those are the primary grounds. And the grounds which are not very very much solid, but usually the submissions we start with without prejudice to above are the ones wherein which are usually
just to give an example, like I am defending a case on a classification. I have cleared the goods, let's say under X classification, department is saying Y.
Yes.
I have to first, primary will be I will defend X.
Correct.
Alternative can be, if not X, if not Y, then it can be Z also.
Correct.
So sometimes your alternative ground can be better than your primary count, completely depends on the case to case. Giving the mic to Kapil now, I will be rushing now. Thoda jagna padega. Now, these are primary, alternative. there can be contradiction also.
Yeah.
So if you can give some examples how to avoid contradiction while taking the ground.
Sir, just to answer very briefly, sir, contradiction can arise when you are disputing the fact itself. You have your right, and you are well within your right to take the alternate plea. So if you are not agreeing, assumingly without admitting, if you don't agree, then please refer to this set of ground and allow me a benefit. Example, sir, I'll give you an example to illustrate it. So there is a classical dispute, sir, on the cross charge. There is a dispute on valuation of cross charge. So you put your grounds on a primary side as to why your valuation is correct. So that is a primary ground because that is the most skill point that you're harping on. Now, sir, amplifying it further, the alternate ground in this could be, which you want to explain and you want to differentiate from the main ground, assuming without admitting. Even if we consider the valuation is under and it has to be added to certain more principle, considering rule 28, I am allowed 100% credit to my recipient. Therefore, please look at those circular, please look at those rules and allow me the benefit. Sir, the summation is, according to me, is I should be able to differentiate the alternate ground and support why alternate ground should hold good at the same time without contradicting to the earlier fact that I have mentioned on the primary ground. If I am able to do this, I can have as many as alternate ground to put my ground because these are not actually substantive, sir. They are rather a primary example and they should be applied in that case.
Yeah, now I think time to pass on the mic to Pawan again. He's looking at me. So Pawan, quickly coming to you. Now, enough of grounds. Suppose we lose at GSTAT, which is quite possible. We have tough judges sitting next to us. So, will you plan your next move at this stage? Will you have that high court strategy in mind while putting these grounds? What is your take on that?
Yeah, as I mentioned, we always take our grounds considering in mind that we may have to argue till Supreme Court. And I think you are asking like whether we should follow this adjudication proceedings through show cause notice, appeal, tribunal, or we should approach directly to the High Court. It always depends on matter to matter, right? So there are as I given the example of development rights, so I directly challenge the show cause notice to the High Court on development rights. So court initially agree on accepting this writ, but later stage they have denying to accept because they were saying that go to the adjudication proceeding. So I very much convinced them, no, Bombay High Court is already on this. So then finally, why again this alternative ground is coming? Once they are convinced but they do not want to entertain that particular question, then they directly go to some another question. So as I extending the example of this alternative ground, in a corporate guarantee matter, primary and secondary ground. So in a corporate guarantee, yes, we know now everyone is saying GST is payable. So our primary focus on the valuation, that full credit is available. So we have argued the matter very well on that. And then at later stage, we also pursue that it is not payable. So this always primary, secondary should be balanced in this manner. Or always drafting should always be from every stage should be in mind that we have to argue till Supreme Court.
Quickly, before I move to the next topic, quickly, each one of you, one example of where the procedural ground has won the case for you. Procedural ground has won the case for you. You have strong on merits, but ultimately what clicked was the procedural ground.
Okay. So I think recently what we witnessed was that the service of order, and it was, I think, the service of order was not communicated properly, and the appeal was filed and it was rejected on the ground of the department was saying that this is not within the limitation, hence it should have been rejected. We took a procedural ground that the communication by way it was communicated was not proper, and it actually helped us in getting the remand back, because this lady who was the appellant was an old lady, and wherever she was residing there was a lot of change of address which was happening. So she was not able to get the order in the proper manner. So in that case, the court said that let her file, it should be remanded back and a proper hearing should be given, and they condoned the delay in those cases. So this was one procedural ground of communication which happened practically.
Similar kind of case wherein the order was, the period of limitation had passed So order with the watermark, draft, and all those things was like, assessee was called in person and was such kind of order was served. So we had to file a manual appeal, and therein we got the relief that, order per se was never served where it had a draft watermark on it. Because of it.
Generally on procedure, sir, it is on a manner of service of the order. So there are many examples that we face is order has not been served upon, and that forms a basis part with respect to applying of limitation, because limitation applies from service itself. So improper service of an order is the main procedure on which we harp whenever we take. So we need to see whether the service has been done or not. If yes, effective service has been done or not, in that case you defend. So these are my experiences in terms of limitation and procedure.
Yeah, I think sometimes limitation becomes more relevant. Just to give you one example, before I come to Kapoorji, I think just to give one example, we were having a matter before tribunal, and it was a DGCI investigation, 2000 plus pages show cause notice, RUD, and the question was whether the unit actually was set up during a particular period or not. When we went through the show cause notice, there was statement after statement of all the employees of the company, managing partner, everybody, saying that okay, we were not able to set up and all those things. Somewhere in one of the RUDs, there was a physical verification report of the assistant collector of that jurisdiction itself. Now, strangely, when the matter went to the tribunal, what assessee argued was, what are you saying that a unit was not set up? The DGCI never raided my unit in Uttaranchal. They raided my unit in Noida. There is a report saying that the officer has visited the premises of my assistant commissioner of my jurisdiction. Where is a question of limitation, 5-year extended period? Where is a question if they are fully aware that the unit was set up? So, and it really clicked. It clicked like within a minute. Judge was, are you pressing on the limitation? We said yes. There was no need to went into the merit. So sometimes, limitations like Appel and others are mentioning can change the, state of the matter. Coming to Kapoor, sir. Sir, now, I think very clear you will get a bulky appeal. It's very clear. They have taught the audience perfectly. Take which ground? Silly ground, stupid ground, every ground. What do you prefer? Do you prefer, like in CSTAT, there is a, now there is a trend of giving synopsis. What do you think as per you? Will it be actually useful for the bench to manage the matters if we have, say a synopsis to get the hang of the cases? What is your take on that?
I think it's too early for me to really say, because I think as we start moving ahead, but my personal feeling is definitely synopsis definitely helps. So, as you said, that appeals are going to be very long, and there can be multiple issues also, and a lot of I would say the ground which you have prepared. So a synopsis definitely helps in coming to the conclusion fast as to what is the issue involved, what kind of, whether it's a classification dispute, what kind of dispute is there. So those synopses are always helpful to the bench in coming to the, I would say a preliminary kind of decision about the, not decision, I would say, at least you can make up your mind. This is about actually issue which is, and as then the case proceed, more discussions come. So,
of course,
this is my view.
No, I think, sir, we totally agree.
I have not faced it. Maybe as the bench goes, things would come more clear. But this is just offhand you are asking. My feeling is that.
I think we totally agree with you, sir. Thanks for your inputs on that. Now I'm going to touch a very sensitive point. If everybody wants to have water, please have it. Because in the first session, sir, with due respect, nobody asked about problems in portal. Now opening the house for them. Starting from Prerna, you know, Pawan, can you pass on the mic? What are the practical challenges you are facing? Be open. Nobody is listening. Everybody is sleeping, waiting for lunch. Be open.
Okay. I think the biggest problem, I'll just start from the basics. While you create a login of a taxpayer, the OTP at times takes so much. it becomes at least so difficult sometimes even to register the OTP or taxpayer. And even as a professional, when you drop down it, I think for me, it took 3 times for me to do that. So at least if that can be, and we have 2 OTPs to be, one email OTP, one phone OTP, and the CAPTCHA is also there. Certainly, it can be resolved by having a one OTP verification or a one CAPTCHA verification. If that can be simplified, at least it saves a lot of time. Second, coming to the, when you enter that portal where you file an appeal, I think one problem has been resolved yesterday only, was that you could not see all the documents which were uploaded before going to the fee tab. Now, I think that has been resolved yesterday. So that's a good move, I would say. Another thing is sometimes, if you don't save it on the portal, you just log out, and then you're going to again have to refill the tabs of the GSTAT appeal. That's the second. Third, I would say, which I think Pawan was also telling, while let's say if my appeal is of 600 pages, I have to upload the entire 600 pages first in the portal. Then I have to split the 600 pages into different things, which is a statement of facts, grounds of appeal. There are, I think, total 6 to 7 bifurcations which has to be done. I think if the bifurcation has to be done, then why do we have to upload the 600 page again? Because it takes time. If that can be reduced, that will really help the taxpayer to do that.
I think, Prerna, you have not seen our appraisal form for that matter.
We come to the, I'll just like to mention to you that like Honorable President Sir was telling in the first inaugural session that, a committee has been set up, and in that committee we are taking various issues related to portal, issues related where requests are coming, there is some issue regarding GSTAT rules, or where FAQ can be issued. Like these various categories have been formed, and these portal related issues we have received a lot of them. So I'll request you through the chamber, you can forward, we'll try to, and immediately as we are receiving it, we are trying to take action also, like you very rightly said. But at the same time, I'll tell you, like the President Sir said in the session, that there are some security protocols which have to be ensured in this kind of portal. Like if you see GST and also, and these kind of portal security is a major issue, one of the major issue. I would not say major, one of the major. So this kind of many times of this OTP check, cross check, this feature could have been introduced to ensure higher security for you. Basically, idea is, both taxpayer data, whose data is there, so that is secure. As far as this space is concerned, I think it has increased from 20 MB to 50 MB now, the data. And the number of pages have also been increased. We are also looking into that issue regarding that characters, 2000 characters limit is there. So that also we are looking into, if it can be increased. So my request will be, you have issue, kindly bring it to our notice. We'll try to resolve it as fast as possible. Because we have to go through NIC actually.
Definitely.
So we are, President Sir is very, very active, I can assure you on this. He himself has is taken the portal part, and along with me, I am there with him on the portal issues. So if the portal issues are there, please do bring to our notice.
Definitely, sir, we'll do that.
I think this statement deserves a big
A
round.
big round.
Pawan, you have any checklist in mind considering all these things while filing? So what my experience I've been told by my team members that if you have real checklist in mind, it doesn't take half an hour or maximum 45 minutes to upload it. First time it will take a day or so. So do you have any checklist in mind, top 3 items which should
What
be ready?
we have done actually in our firm, first of all, I take a meeting of all team members. We have first gone through all rules, and as sir said, see the videos also. So we are totally aware about the drafting requirement, the font and all things. So if you see the checklist on the GSTAT portal comes at the last, all questions are related to the APL 05 form or the formatting requirement. So that is not a big challenge for us if we are aware about all these things. So basic, and the experience comes from high courts also, because high court have so many requirements. So similar requirements are there. But yes, there are certain extra requirements, like there is one column of case history. So what happens in the high court, we give the list of events. So in the case history, we give entire case history by writing in a Word document. But now putting one another after another case history in the columns, like ARN number of the investigation, then ARN number of SCN, then ARN number of APL. What we do, we have a habit of mentioning in the Word file, and even I could also accept those in the Word file. So putting it in a form on the system is creating an additional task for us. And at this point of time, when we have to file 50, 100 appeals at a point of time, so it is a difficult task for us. And although that is a point, my team has suggested that checklist is asking each and every question, 28 question one by one. So we mention all points together and then single check, all agree, all seen, then proceed with that. Instead of stating everything, yes, 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 yes. So these type of things should be taken.
I will definitely look into this, the issue which you have raised. And my request to you will be, if you have some best practices which are in your knowledge, probably while you make a representation, you can suggest that also. Sure. So because that will help us in, coming to the decision faster.
Thank you, sir. Thank you so much. Can you pass on to Kapil? Kapil, considering the word limit and other things, have you also trained your people while drafting what should be kept in mind, considering that there is a restriction on the file size, fonts? You have also worked around that?
So, okay. So, couple of things with respect to drafting. A, you need to fill up the entire enclosure properly, such as your deposit, etc. Secondly, you must be able to put your grounds in 2000 word, which I'm informed that it is being increased. Plus, the annexure should be paginated, they should be mentioned, and they should be completely in the sense of whatever is required, self-attested documentation, department orders, they are supposed to be filed along with it. Sir, it is a tedious job, no doubt. But once and twice and thrice you do it, you are able to get familiar with it. So it gets into your muscle memory, sir. My team has 2 members and they are doing it effectively. They say it takes 30 odd minutes for them to do it. But they will start only when they have document, because the frustration increase from the fact that you are sitting when you don't have a complete set of document. So if you have a complete set of documentation and you sit, I think it takes 30. All the more reason, sir, it should be reduced. I personally feel it should be reduced. But certainly to say a new system should be put in perfectly at day one itself is a challenge for everybody, sir. It's a bit too much for us to ask also on that sense.
I think considering that all the technical points he has also captured.
No, just I really appreciate. I wanted to say that it's initial days. Definitely, when we make a first attempt, 2 attempt, like there will be some difficulty. I don't deny that. But I think what he excellently put up is that once you do it 2 or 3 times, then you know which are the columns, and please keep all the documents ready. It's not that you just start filling and then you realize, oh, this is not available, it is available somewhere else. Then you go and search for it. Then another point she raised, I forgot to answer, was that it logs out. So there is a security feature of 30 minutes actually. If you don't do anything on the portal for 30 minutes, it will log out. It's again a security feature. It is kept there. And it is there in most of the sites we work, because it has to, then the log out. So it's a security requirement. So, and just stick it.
It's required also.
It starts working.
No, I think it's required also that way. In fact, many of the airports where you have this boarding pass, international airports, where give the printout, the same thing.
Oh, that point I'll note it down. That I'll see.
So I think too many portal challenges. Just sort of your word on it. Considering that we are in India, and light कभी भी जा सकती है, phone कभी भी बंद हो सकता है. What is your safe time? Timelines to file these appeals?
Sure.
Or will you wait till 30th June?
True that, but in case of any appeal, broadly we have 3 months to file an appeal. So what we do is, in case if we have it from the day one itself, or in first week itself, we try to formalize a strategy, speak to the client in first week or first 15 days. Thereafter, next 1 month we would be focusing on drafting appeal and internally doing the research, deliberating and all of that. Thereafter, another 15 days for the client to come back to us with his views, or in case if he wants any additional submissions, or if he has any additional evidence that he has been able to collect and all those things. And we try to ensure that, the appeal is filed 15 days before. So in case there is any weekend, there is any holiday, or the authorized signatory or anybody is not available, or it has to be submitted.
प्री डिपॉजिट नहीं हो बैंक में, वो तो बहुत बड़ा नहीं तो therefore 15 days.
So that's we have to inform on day first week itself, sir. Please keep available this much funds in your bank.
So coming to the last topic, I think though it has not been deliberated much, but it's very crucial is the additional evidence. What is this additional evidence? What do you mean by additional evidence? There is a difference between additional grounds, which there is no limit. That's very clear. And additional evidence. I'll start with you, Prerna, on that again. In what circumstances do you think tribunal can entertain such additional evidence?
Okay. So as you all know, Rule 112 of the CGST gives us the reference to the additional evidence. So additional evidence is not a rule, it's an exception. Okay, we need to understand. Though to entertain an additional evidence is only, there will be circumstances which has been given in the law, which are four either you were not able to present it, for some reason you did not get the chance to present it before the adjudicating authority, you were withheld or something. But at the same time, there's an inherent power which is given that tribunal can direct, if required, additional evidence can be taken on record. That's a provision to the rule. So usually if it's, as the GSTAT will be the fact-finding authority, they do have the power to take additional evidence on record if it is necessary to give justice to the case. So that's the rule. It depends.
Just pause there for a moment. I give you a real life example. Again, too much of Gyan doesn't work. Let's talk about real life example. Now, let's take 2A, 3B. Simple case. I have filed a RICO at the first level. The assessing officer never argued. I went to the first appeal. I again modified the RICO, filed it again. The appeal order says it should have been invoice wise, therefore I reject it. Now at the second appeal, is filing this invoice wise RICO as per you an additional evidence or something which has, for which I need the permission of the court, or is something which is already filed before?
See, the invoice level RICO was not given. It's an additional evidence because you did not give it invoice level RICO.
I have already given the RICO. I am building upon that RICO because I have given you the reconciliation of 3B to A. So of course, that is a summary of the invoices I have given you. Now he's saying you should have given me invoice wise. I am giving you invoice wise. Why it should be?
So this is not an additional evidence, I would say, because this was only there, and the court, it's a final fact-finding authority. They can. It's not an additional evidence, I would say. Let's say there was a export documentation, and you did not give it agreement at the point of initiation of your proceedings. That probably is an additional evidence why the agreement of export was not given. But something which is already there and you give a detail of it is not an additional evidence, I would say.
Saurabh, you can give an example which will qualify as additional evidence.
So suppose in case at times when the audit or any adjudication is happening, in case of export of services or export of goods, you need to submit the FIRC and all these things which are not readily available, which may not be readily available because the bank may take time to generate and give it to you. So in that case, you can take present this as an additional evidence that this was not available at that particular point in time, and that's why I
think you've given a perfect example of how additional evidence should be considered as. For export or service, I have to submit FIRCs. FIRCs were not available was not given available to me. Now it is available at the second stage. My export of service has been rejected for the want of FIRC. That is a perfect example of additional evidence. I think on that note, I go to Kapil quickly. What is your view? How the tribunals are going to treat this additional evidences?
My personal take, going by the history also in the CSTAT, additional evidence is supposed to be brought only in 3 circumstances, sir. A, you must be able to convince the judiciary that this was circumstantial and was not available when I did the act. So therefore, that is the first and foremost which he
for the want of documentation.
Correct. First. Secondly is that I have made a submission at the first level, but it has not been considered by the initial level adjudication or the first appeal. You must demonstrate that. And third is the discretion argument, wherein you have to plead that it didn't appear but it is striking to the cause of the main ground. Therefore, please allow me. There you enter into a zone of discretion of GSTAT to allow you to do it or not. But sir, going back to the first principle, the sum is it has to be allowed only on these three circumstances, and it is not a matter of right to produce additional ground or argument at any stage and any point of time. Because whenever you are sitting for a pleadings and drafting of a pleading, you must ensure at the first level itself your pleadings are complete. You can amplify those pleadings n number of times, but to add additional ground which was not taken earlier is a problem, sir. What I see personally, excise also had the same provision 35F, now also has the same provision on a similar line on rule 45, sorry.
But I think there is one quick difference. New members said Nyay milega, nirnay nahi. I think every additional evidence will get admitted. Coming to you, Pawan. Last on the additional, do you think additional evidence can backfire?
No, additional evidence will not backfire. It may be rejected, but as President Sir said, see, we will consider that. And what we do practically, if, as I said, during the drafting, we get to know that this is the important document which we have to add. We add during the pleadings, and argue it. And as a practical experience, generally when your merits are strong, judges are allowed to show any supporting document to them. So this is a practical experience of it.
Okay. Quickly, final words, closing remarks. Kapil, you want to start?
While we all know that we are developing it to a stage wherein we are coming close to the GSTAT becoming operational, I think, sir, I want to submit, I am eternally optimistic. I want to sum it up in a sense that yes, the processes are developing, the systems are developing, but as a duty payer of a taxpayer, we should also be approaching in a systematic manner so as to make it easy for you to decide, considering the paucity, plus the procedure from your side can be somewhat streamlined to make it easier for taxpayer. So it will help us in a long way in terms of deciding the pendency of matter, because then you will see some set of uniformity in terms of appeal being followed and perhaps faster decision making in terms of disposal of the matter, sir. That's what I see.
Sure. So firstly, I would like to say that, in terms of technical issues that we have been facing with the portal, they have been broadly kind of taken care of. Of course, there are challenges that we face. So that is one good thing. And even during the opening remarks, so what we heard from the Mr. President, it was that, they'll be having a lenient view, which is also very important that, given that so many years of backlog and even GST was also new. So per se, the taxpayers were not very much informed, and even the adjudications at earlier stage were very premature in that particular sense. So that is one good thing. So I hope that the intention and the psyche that is behind this is continued and is actually on paper.
Thank you for closing on the positive note.
So on the drafting part, I just want to conclude that although we take so many legal grounds, but the factual grounds which we take and to prove our facts should be taken care. So I have seen so many appeals which we come to us at the appellate stage that the facts have not been dealt properly. So facts should be first dealt properly, then legal grounds, as sir also said, that we will accept, and it is acceptable, legal grounds is acceptable at later stage also. But if you don't put facts properly in your at first stage, then your case will be weaker. So we should focus also on the factual arguments.
Last, since we are in a session of drafting and filing, your appeal should be as simple, credibility and clarity, and cross-referencing should be there so that it's easy for the court, it's easy for the tribunal. If that referencing can be done in a drafting stage, that will be helpful. That's why, so it makes life simpler for all of us.
Sir, I think last question is to Kapoorji. I'll not make it simple for him because it's the last one. Just a brief history before I ask you this question. I mean, when 2017 GST came, I think most of my professionals were in this auditorium, and we had group of officials representing Government of India. What I recall was there was a lot of talk about advanced ruling authorities. I mean, GST advanced ruling authority was looked up. If you can recall, I think most of you are, I can see the nodding heads, right? So the feel which we got from the advanced ruling authority is things are going to get settled. GST is a new law.
You go to the advanced ruling authority, he will give you an order, he will tell you what is right, what is wrong. Throw away all the professionals. Batra ji was looking at me, हमारा क्या होगा? मैं Batra ji को देख रहा था, उनका क्या होगा? और suddenly advanced ruling authorities पे application 17-18 में file हुई. आज इस कमरे में एक, can I have one raise of hand who wants to go to the advanced ruling authority? For a simple reason, on the same issue you will say one advanced ruling authority taxable, another saying non-taxable. One will say 5%, another will say 28%. Now GSTAT is also not just a principal bench or a state bench. It's 32 benches going to sit. Do you think, sir, we'll have some judicial certainty at GSTAT? What is your take on
it? Definitely, I am very, very optimistic, and I am sure, our Honorable President sir said, our first and foremost endeavor will be to deliver the justice. So, as far as advance ruling is concerned, I have pointed out, initially, this thought was that definitely, because there will be interpretation issues, there will be, GST is a new law. So, and unlike earlier cases when service tax and customs, and you had advance ruling which was at pan-India stage. So here being federal country, advance rulings authorities have to be created in every state. So, and definitely, this issue came up that different advance ruling authorities are giving different interpretation to a particular matter. And in AAAR also the appeals have gone. In many cases they got reversed. And in many cases, they got the view which was taken by AAR got confirmed at the stage of AAR also. So, my feeling is that, GST 80 being a pan-India, though there are benches we have different benches, but still, a principal bench will have a very, I would say, crucial
role.
Yes. Because the question of law, ultimately, in many cases would be decided. And this will more or less will be followed. And it will bring a lot of certainty. The uncertainty in interpretation will reduce. And, I would say the taxpayer confidence will build up in the institution. Yes, I am going to get the justice at some place. And secondly, I think even for the executive, because I have been part of the executive for a long time, and many times we follow in tribunal orders, and tribunal GSTAT order have been bringing a lot of clarity. So in a way, once the GSTAT orders start coming, it will bring a lot of certainty in the executive side also. When any additional commissioner or additional first appellate authority is passing the order, and you have an order by a GSTAT on a particular issue. So I think there will be some kind of higher coherence and higher this thing in the executive side also. So let's hope
Thank you so much,
works
sir.
out very well.
Thank you so much. Big round of applause to Rajiv ji, and hoping that next year when we meet again, we have some good orders from you to take it. Thank you so much, sir. Thank you.
Thank you so much, sir. But before I think you move, we will like to present memento. And I'll once again request Ashok sir also to please join us on the stage. Many thanks to the esteemed panel here for the outstanding session we had. Your expertise, thoughtful insight, it was very engaging. I will request now to please present the memento to our esteemed chair of the session, Shri Rajiv Kapoor ji. Thank you so much, sir, for your time, for being with us and sharing this valuable knowledge with us. Thank you so much. I'll also request, sir, to please present the plant to thank our esteemed panelists for sparing time and being with us. I'll request to please present this to Pawanji and then to Prerna ji. Please. I request our chair and co-chair to please present plant to them. Thank you so much, Pawanji, for being with us. So requesting you to present plant to Pavanji also and to Kapil Sharma. So this was really wonderful session we had. So please present this to Saurabh Chaudhary ji and Kapil Sharma ji. Thank you so much for your time. I'll request you to please stay back for the group photograph also, please. That will be for our remembrance. We have very wonderful session, but post lunch. So I'll request all of you to please proceed for lunch. But not to forget that after lunch we have a very, very important session, and we will start our session maybe by 2:30, 2:40 max. We will try to do so. So I'll request all of you to please quickly have your lunch, and please come back for the another very important session. Immediately after lunch we have the session. Good afternoon, all of you, and we will start now our session post-lunch. I can see many of them, you are relaxing. So this session is also going to be very interesting for all of you. So I'm sure you will be all alert and you will not get time to sleep. So our next session is about presenting before GSTAT benches. And we have our session in charge, chair. I'll request judicial member, Mr. Pramod Kumar Rai, GSTAT. Pramod Kumar ji, I'll request, I think he is not here. Pramod sir, please, requesting you to please join us on the stage. Sandeep Garg ji, co-chair, Indirect Tax Committee, PHDCCI, please join us on the stage. Vaibhav Jaju from Dhruva Advisor. Gaurav Gupta, Chamber of Advocate, Gaurav Gupta. Soumya Panda from SK Panda and Associate. I'll request all of you to please join on the stage. And now I'll request Sandeep Garg ji, co-chair of our Indirect Tax Committee, to moderate the panel and take it forward, please.
Hello. Good afternoon, everyone. लंच के बाद का सेशन थोड़ा नहीं बहुत मुश्किल होता है सबके लिए। आज हम जेस्टेट के बारे में डिस्कस कर रहे हैं। जो लोग जेस्टेट इज़ न्यू ट्रिब्यूनल और सेस्टेट की प्रैक्टिस करते हैं और काफ़ी टाइम से करते आ रहे हैं, दे विल वेरी वेल अंडरस्टूड कि लंच के बाद का सेशन वहाँ पे कैसा होता है। मेरा मन तो यही है कि पहला क्वेश्चन मैं यही पूछ लूँ कि सर जब भी हम ट्रिब्यूनल प्रेजेंट करते हैं तो लंच के बाद ऑर्डर नेगेटिव क्यों हो जाते हैं जो लंच के पहले पॉजिटिव हो रहे होते हैं। एनीवे, थैंक्स टू ऑल। फर्स्ट ऑफ ऑल थैंक्स टू प्रमोद सर, आवर जुडिशियल मेंबर हेयर, टू स्पेयर हिज time from his busy schedule and come here and share his valuable insights on this particular topic. प्रमोद सर से जो आज वैल्यू एडिशन हमें मिलेगा वो बहुत अलग होगा, ये मेरा मानना है। इसके काफ़ी सारे रीजंस हैं। पहला रीज़न ये है कि प्रमोद जी ने टेबल की हर साइड देखी है। एज अ रेवेन्यू सर्विस भी देखा उन्होंने, क्योंकि हम एक्सपीरियंस कर सकते हैं कि जब हम क्वेश्चन पूछेंगे एडजुडिकेशन ऑर्डर्स के बारे में तो सर विल अंडरस्टैंड कि वहाँ पे क्या गलतियाँ रही होंगी। सर ने प्रैक्टिस भी देखा, एज ए कंसल्टिंग प्रैक्टिस भी की, तो दैट आल्सो साइड सर नोज। देन सर ने पीएचडी में भी एज ए चेयरमैन सर्व किया है, तो सर नोज की हमारी सिचुएशन क्या रहती है। Now, sir is being a tribunal member, so sir, of course, that experience will enlighten us. Thank you so much, sir. हमारे साथ गौरव गुप्ता जी हैं, वैभव हैं, सौम्या हैं, other panelists. So one by one we will raise some issues which has not been discussed yet. फर्स्ट सेशन में हमने जो फर्स्ट टेक्निकल सेशन था, हमने लॉज रूल्स रेगुलेशंस की बात की जेस्टर से रिलेटेड, जो तुषार जी ने मॉडरेट किया. उसके बाद शिवम जी ने मॉडरेट किया, जिसमें हमने ड्राफ्टिंग के बारे में बातें की कि अपील्स कैसे ड्राफ्ट होगी, क्या उसमें ठीक कर सकते हैं, कैसे उसको बेटर प्रेजेंट कर सकते हैं विद सम रूल्स एंड रेगुलेशन. हियर इन दिस सेशन पर्टिकुलरली वी विल टॉक अबाउट रिप्रेजेंटेशन, हाउ द काउंसिल should represent the matter in a better way before gestate tribunals. We will more talk about soft skills and skills attribution related to the representation. So, sir, on this topic only, first question to you, being a gestate member, so we have anyhow to represent before yourself, good self. So, from a branch perspective, what you think that as a council should represent in a better way with the professionalism, with the clear thoughts, with the fair facts, and when he is representing adverse material as well. So what is your thought on this, sir? What is your expectation, basic expectation from the council who are representing cases before your good self?
Good afternoon. I have worked for 10 years in revenue services and 20 years as an advocate. So 2/3 of me is advocate. So I understand your pain points. Minority, 1/3 is revenue officers. So I also understand their excesses. As far as being a judicial member, the work is yet to start. So now, taxation disputes are very different from other types of disputes. Tax liability is not a contractual liability. Therefore, while arguing, you should not focus much on who said what. Irrelevant. And you should not, even if it is a covered case, you should not start with case law. Never presume that judge has read the file. Always presume he knows nothing. You have to teach him. So for every case, there are certain facts, relevant facts. Again, every fact is a fact. So when you start your case, first summarize your case in 1 minute. If you are unable to summarize your case in 1 minute, means you have no case. So what is the core issue? What is the allegation of the department? They may be right, they may be wrong. But the way you understand, what is the allegation? Narrate basic facts. And while narrating facts, satyam vadet, priyam vadet. माने सच ही बोलें. चूँकि बेंच में कई बार झूठ बोलना बहुत भारी पड़ जाता है. There are other side also to correct, and then you spoil your reputation. So always correct facts. Then you state the relevant law which was prevailing at the time of dispute, and interpret those facts and law in your favor. When I am saying narrate facts, does not mean that you have to lose the case or you don't have to defend your case. Same facts, you will have different interpretation, department will have different interpretation. So state facts, state law at the relevant time, and interpret law with respect to given facts, how it leans in your favor. After doing that, then cite case laws, whether a similar situation has been decided by a superior forum or a coordinate bench, etc. So once you do that, then you are through. So fact, relevant law and case law. That should be our approach. And when you give a short summary at the very beginning, then judges also understand what is the core issue involved. So when you argue and elaborate further, they are also focused. Many times we see in the court, you start from somewhere, and after 5, 6 minutes, 10 minutes, judges ask basically what you want to argue. So therefore, you summarize department case. In the summary itself, you say how you propose to demolish their case. So fact, law, case law, that should be an ideal approach for approaching any forum, including GSTAT. Thank you.
Thank you. Thank you, sir. Moving forward, my question to Gaurav Gupta ji. Gaurav ji, as we all know that when we are representing the case, it's not only the legal merits, that's of course legal merits play the role, but the way you are representing, oral submissions, oral representation also play a vital role in cases. We want to understand from you how as a council we should articulate and what communication skill, type of communication skill we should represent our matter so that it can represent in an effective manner along with the merits of the case.
Sandeep, this has always been a very tough question for any council. See, there are 3 golden rules. Number 1, simplicity is the key. Keep yourself in the most simple, plain English as possible so that you don't have to be great before the bench. You have to be someone to whom the bench is receptive. So keep yourself plain, simple. Second, don't use for jargons. Don't go for some maxims and something which you cannot put outrightly and very clearly into your case. Just because you want to show that you know something, that does not mean that is relevant for the bench. And third is, don't get into, and this is very prominently said earlier also, don't get into a case law diarrhea. You are presenting 20, 30 cases, out of which there are some 2-3 lines which are relevant. When you are presenting cases, please be very, very selective. If it is a case which is actually, completely in your favor or against you, you have to choose the cases in such a manner that you are presenting only the relevant cases. So don't vomit out all the cases before the benches. You have to keep everything into a simple, plain, straight manner to the bench. The more you are clear, the better it will be for you and the matter.
Thank you, Gaurav. We will come again on these specific points with the relevant, I'll say, case law or something, practical scenarios. Before that, I'll ask Vaibhav also. Vaibhav, as per you, what are the tricks and tips to effectively represent this matter?
So I would say this is a difficult topic to answer. And the reason is, if all of us become effective in argument, I fear that, anti-profiteering investigation would be done in advocacy fees. So started on a lighter note, but I will start further on 2 disclaimers, which I would take liberty from my co-panelist also. These disclaimers are from all of us. I have not asked them. I am just reading out. We need to understand 2 things. The first disclaimer is we need to understand the situation of the bench member. I think they are overburdened doing an uphill task. According to me, it's humanly impossible because generally in a day, you do a hearing of 3 to 4 matters. The bench member sitting there is hearing 40 to 50 matters with the onerous task of delivering justice. So this is first rider. Second rider, we are legally and morally bound by professional ethics. Be it ICAI or Bar Council, we need to present the truth, we need to present the reality, whether it goes against us. Now with this riders and post-lunch session, I don't want to make it one-way monologue. So a quick poll on show of hands. How many of you have watched the movie Sanju? Quite a few. Next question. How many of you did not like the movie or the character portrayed in the movie? Did not like it? No one. Okay. Third and last question. How many of you feel that my question on movie Sanju had any relevance to this session? It has a relevance. Too much learning from movie Sanju for this GST litigation. And what is the, learning? Because GST nowadays is not about section, rules, principles. It is more about, increasingly about persuasion. And persuasion is an art. We need to learn and understand this art from this movie. Because honestly, tell me, before Rajiv Hirani made this movie, how many of you liked the deeds or the character which was portrayed? If you compare the media reports which were there and how it is portrayed, probably in the eyes of the viewers, he came out as a hero, and if not hero, then an innocent person. So this is what we need to understand, that litigation is an art of storytelling. The story should be simple, lucid, digest easily. Once you are being heard in a courtroom, the bench and the court feels like, light, and you are felt right. So this is something we need to understand from this movie. And cases, which has not, I would say, cases are not lost because the law is weak or the facts were weak. But if I need to say, if the facts are well organized, if your points are well prioritized, and if the arguments are communicated effectively, then, you tend to win before the bench. So before the tribunal, brilliance is useful, but clarity is something which is, deadly effective. So basis this, I am going to share some 14 principles which I say survival principles of GST advocacy. 14 principles, 14 minutes. We go through this, and this is how I call it. The first principle, never start with loss, start with pain. Because no pain, no gain. Now coming back to our Guru movie Sanju, the character was showcased with, pain. And therefore, he came out as a, I would say, innocent guy in the eyes of the viewer. So typically before the bench, as Pramod sir also said, what 4 things, it is being looked or it is being anticipated from you. What exactly is the dispute is? What injustice are you alleging? What is the revenue implications? And what is the legality or absurdity you are trying to, prove? So if I have to give this through an example, that generally section 16(2)(c), where, the credit is denied because supplier has not paid tax. Typically, how would advocates approach is, Your Honor, section 16(2)(c) read with rule 36. No. I would say by this time the benches, half of the bench is still opening the file. Courtroom is today's time is more like a Netflix. If you sound confused within first 2 minutes, the attention drops. Rather than the approach would have been, if we make it more simple, which sir said, in a simple factual narrative matter. Your Honor, this is a case where the tax has been reached to the government. There is no allegation for fraud. There is no revenue loss, and yet credit is denied to me because someone else has done a non-compliance. Now suddenly the bench, is starting to hear you. They are interested in your argument. So sum and substance is, facts create emotion, law creates conclusion. Coming to second principle, reduce the case to one sentence. Again said by sir. In your entire matter cannot be summarized in one sharp sentence. I would say you have not understood your case. Because every matter has a central heartbeat. So you may say that, there is a taxation without authority, or there is a double taxation in guise, there is a retrospective punishment through interpretation. The moment bench remembers your one statement, your chances improve dramatically. Instead of saying that, again, Gauravji said, instead be simple. Instead of saying impugned order suffers from manifestly arbitrariness. Now, using such jargons, my lordship, the department's entire case fails on one simple point. So simplicity is not weakness, it is a control. And according to me, the best compliment from the bench is not when you get a, compliment, Mr. Counsel, excellent arguments. The best compliment is, we understood your point, and that is what we are there to. Third principle, I would say, do not argue all points with equal passion. This is the biggest mistake in tax litigation today. We go and we argue on limitation, merits, constitutionality, natural justice. And that what happens? With the same force we argue. The bench thinks that everything is important. Maybe nothing is important. So you get into that zone. So as a good litigator, you need to know which points you need to press, which points you need to whisper, and which points you need to abandon gracefully. Strategic surrender is also advocacy. Sometimes dropping a weak point increases credibility on strong points. So I follow one golden rule. Don't argue everything. Argue what wins. Maybe select your 2-3 points and argue on strength and not on background. And very important, when we make a submission, we need not follow, the entire sequence of the appeal. What mindset we have is, मैंने इतनी मेहनत की, आज तो सब बोल के जाऊंगा, सब समझा के जाऊंगा. No, not required. That's a cardinal mistake. Because once you file an appeal, typically the hearing comes after few years. During this interim gap of few years, there is a situation where there would be legal development, you need to put additional grounds or you need to put additional case laws. And it is possible that while arguing, you even are not required to refer the grounds which were there under the appeal. Your additional submission is sufficient. Secondly, please evaluate the sequence in which you need to argue. Because while you have prepared, you would have done one sequencing, but you need to change that sequence. Again, also prepare before going to the courtroom which points I don't need to consider, or I may consider it depending on progression of the matter. Third point, very important, you need to be very polite and humble. So you can be firm in your position, but at the same time you can be humble and polite. And you need to understand, what you need to speak, when you need to speak, when you need to start, when you need to stop. That is art. On this, on a lighter and a real side, I will give you a story. You have prepared an appeal. The appeal has 7 grounds. You start with first 3 grounds. The bench is convinced because we order it in, the strength and the hold of the grounds. The bench is convinced. Please stop. No, but what we'll do? Sab suna ke jaunga. We go up till 7th point. By the time you go up till 7th point, probably in the mind of the bench members, your aura or effect of the first points have vanished. Your 5, 6, 7 points are not so impressive. So what happens? The matter which was convinced goes into reservation. So what is the learning? If the bench says, we have understood your point, please don't say, my lordship, one more point. Because that one more point is something where the matter goes wrong. जिसको हम बोलते हैं गई भैंस पानी में. So you have to avoid such situation. Fourth principle, paper book management is advocacy. In GST matters, somewhere between annexures 42 to 97, your justice gets exhausted. So I often say that a confused paper book creates a confused hearing. Always prepare indexed compilation, short synopsis, chronology, relevant provisions, and highlighted portions. Tribunal members silently appreciate organized counsels. Just if it gives them a psychological calmness, and maybe sir could ascribe to that. If I today say refer to page 84 of volume 2, he understands that I have not created a bulky this thing, even I have distributed between volumes. And please avoid the statement when something has been asked to be referred to you, that it is somewhere in the paper book. The moment you say such statement, it goes for a toss. Fifth principle, never fight the bench. This is a common misunderstanding typically with young advocates who feel that aggression is advocacy. It is not. You are not into a wrestling ring. You are actually at a persuasion room. And at times, bench may ask difficult question. It is not hostility. It is judicial testing. And if members repeatedly question, that is not, I would say you don't need to get into panic. You try to understand at times interruptions are also engagement. So take this as an opportunity, try to answer the questions and make your case more strong. The most effective counsels remain, calm under the pressure, and you should follow that. Be polite, be humble.
So,
Six.
Vaibhav, just hold on. We will come to you on this rest of the points. So
Sure.
2 points you have very well raised: order of argument and paging and indexation. We will come to that. So just hold on for a minute. We will come to back on this. Sure. So now, so 2 things I feel from morning, which is very important before going to the GSTAT and GSTAT. So before I'll going to the Somya. So सुबह हमने पहले सेशन में समझा कि GSTAT में रिप्रेजेंट करना है तो भगवत गीता पढ़नी है. तो भगवत गीता इज सो इम्पोर्टेंट. अभी वैभव ने हमें सिखाया कि जाने से पहले संजू मूवी जरूर देख के जाना. So 2 चीज़ें हमने आज सीख ली हैं. लाइटर साइड, सॉरी वैभव, बट दिस इज वेरी इंपॉर्टेंट. नाउ I'm moving to Somya. So Somya, so my question to you on our cross examinations. So in many cases, especially when the DGGI or anti-vision making the case, they are making mainly on the basis of the statements and so other facts or records, which is either reliable or not reliable. They sometimes not giving opportunity of cross examination. Same we are not getting even at the time of adjudication also. So what you will choose, that how you will prefer to do the cross examination in your favor so that you can argue the case better and can win the case, though legally it's not empowered. So please tell us on the cross examinations.
Thanks. So, Sandeep is absolutely right. In GST, we do not have an unfettered right to have the right of cross-examination and cross-question the statements or evidences, etc., that has been added against us by the department. So, over here, there are innumerable judgments which is as latest as December 2025 or January 26, which says that it's not an unfettered right, and therefore we are not, the bench is not entitled, or the quasi-adjudicating authority is not entitled to give you a right of cross-examination only because you have asked. Second, because they did not give you a right of cross-examination, can you go to the High Court? The answer is absolutely no. You do not have an unfettered right to go to the High Court and say, okay, I did not get cross-examination, therefore this adjudicating process is invalid and it should be remanded back, or the order is invalid, it should be remanded back. That is scenario number 1, which is the first and foremost. Second, where actually can we use cross-examination, and how can we make sure that the strategy of cross-examination enhances or enables our proceedings or strengthens our case instead of weakening it. I'm a disclaimer, I am only a lawyer, I'm a pure litigant, I'm not a chartered accountant plus lawyer, this or that plus. I'm only a pure litigant. So I will argue from the side of the assessee just to play the devil's advocate, because that's what I've been doing for 14 years. I like to strengthen my case. So what we have done in the past is, if you have statements, let's divide it into 2 parts. First is statements by your own staff, by you, by MD, CEO, etc. Those can be retracted within 24 hours, etc. Make sure 24 hours or 1 to 2 days maximum. If you are not retracted, then you have to give reasons. Yes, this people know or do not know, I'm not aware, but there are, I've had discussions where people don't even know that if you've not retracted, there are methods to retract much later on when you're adjudicating the whole process. Second is, even if I have given the statement, can I be cross-examined? The answer is yes, I can be cross-examined, but depending on situations. Was the statement taken under coercion? Was it under duress? Or did I not understand the question? Or was there any additional factors which led to me giving statement against myself. Otherwise, tell me, why would we give statements against ourselves and make sure that our case is weakened first? Why will our staff give statements against us or himself and make sure that there is a penalty on him? Penalty to usko pay karna padega na, bhale hi demand mere upar hai. So point number 2. So those are the times we can strengthen our case and make sure that we ourselves stand in the court of law and sit, and the lawyer is cross-examining and finding out reasons why the cross-examination is required. First and foremost, before you even start the process of cross-examination, you have to prove to the bench that why does cross-examination merit at this point of stage. First of all, in GSTAT, we cannot start cross-examination just because we want to. The process of cross-examination has to be done at the adjudication stage, at the original authority, where any evidences can be quashed or can be set aside or can be argued. Because we've already learned in session 3 that new legal points, new points cannot be just added on new as part of new evidences in GSTAT. So that has to be really taken care of. Now, second point is when we are cross-examining expert witnesses, we have to be very, very clear that why those expert witnesses need to be cross-examined. They are experts of their field. We know law, but they know maybe phytosanitary, they know cement, they know water, they know a plant, etc. like we don't know because they are PhDs in their business. So it's extremely important to know why that expert has said what he has said and how can we break it. What I suggest, what I have personally done in my matter is bring an expert, a government empaneled expert on my side, make him sit with me and then do the cross-examination. Why should I take the ownership of doing the cross-examination when that is not my forte? Because my forte is law, and the adjudicating authority will let you do it. If there is merit to it, the adjudicating authority will let you take the expert person along with you, and instead of the lawyer, the expert does the questions and he asks, okay, you've said this, but this is the answer. You take your lab results, you take all kind of evidences, etc. and then you arm yourself. Don't go there just by saying, okay, I want a cross-examination, because that is not allowed and that is literally not even, it's like you're wasting the time of the court and everything else that has been said. So 1.2 very short points. Make sure that your expert witness is with you, and second, the cross-examination deserves merit to strengthen your case. That is it. Thank you.
Thank you, Soma. Thank you. So, on the order of the arguments, so in the grounds of appeal, Pramodji, so generally we have the grounds, 3 type of grounds as per my understanding. One on the procedural lapses, second on the merits, where we have the legal merits of the case, third on the factual things. So, just want your inputs. What should be preferred by the council? Before that, I would like to share one of my experience with you. So me and my colleague Medni sitting here, she is by profession advocate like you. So we went for a appeal before custom tribunal to the Hyderabad. We traveled. So during the flight time only, we made a sequence that we will first go with the procedural lapses, then we will go on a merits, legal merits, and then we will discuss factually if needed. Right? So we went there, and our number was the last one, 6-7 more cases were there. We understand that during the hearings of other matters that the judges are more on the factual things. Even on the deposit side, they were calculating themselves at 20% or 10%. So we took first factual grant. We changed the sequence. We took the factual grant. और factual grants लेने के बाद half an hour argument करने के बाद हमारा काम लगभग हो गया था. DR को अच्छी से डांट पड़ चुकी थी और I was understanding कि बात बन गई है. बट माई कलीग हु इज एडवोकेट सी इज सेइंग कि सर इतना तैयार करके आए, ग्राउंड तो सातों बोलेंगे, चुप नहीं रहेंगे, सातों ग्राउंड्स बोल के जाएंगे. रुको, हमारा काम हो रहा है, डीआर को डांट पड़ चुकी है, अपना काम हो गया है, जज आर कन्विंस्ड. सो वी होल्ड ऑन एंड वी वॉन दैट केस. सो बेसिस दैट सर आई वांट टू अंडरस्टैंड फ्रॉम यू आल्सो दैट व्हाट स्ट्रेटजी वी शुड अडॉप्ट इन दिस.
First of all, opinions are opinions. So what I am saying, that is my opinion. You may agree, you may not agree. In my opinion, see, there are technical grounds, delayed adjudication, limitation, procedural ground, on merit, some very strong factual facts, legal issues. You know your case. So you should start with your best ground. If you feel on merit you are very strong, then first you should argue on merit. And if you feel that bench is with you on merit, you may say, there are other grounds, but if bench is with me on merit, I'm not going to elaborate on limitation and other issue, etc. But if bench says, no, argue on limitation also, then argue. So argue your best point first. At times your case is not good on merit, but you are very good on limitation, then start with limitation. So that is one sequence. The second is, as a counsel, you should be astrologer also. You have to sense the mood of the bench. That's what we are doing for last 20 years. I have seen judges who are very good on technical side. In taxation litigation, in number of disputes, a good engineering aspect is involved. Classification issues. What is paraffin? What is olefin? And all those things. So, if you find judges are interested in technical aspects, so your strategy has to be different. If you sense judges are not interested in engineering side, then your strategy has to be different. Like you gave Hyderabad example. Few judges are very mechanical, clerical in nature, they are calculating, then you have to argue like a chartered accountant. Personally, I will not be more interested in those clerical calculations. So if you start arguing like that, I'll say don't do that. Okay. So you have to sense. Okay. See, the job of an advocate or a CA or CS is much difficult compared to job of a teacher. I'll tell a parallel. मास्टर का काम जो है वो शिकारी के जैसा है. एक शिकारी है, उसके पास बहुत एमुनिशन है, लेकिन जब भी फायर करता है टारगेट पे गोली नहीं लगती है. किसी काम का है शिकारी, बेकार है. तो ऐसा ही मास्टर बहुत ज्ञानी है, लेकिन जो बोलता है बच्चे के भेजे में लगता नहीं है, यूजलेस. देयर इज अनदर हंटर with limited ammunition, only 10 bullets. But whenever he fires, it hits the target. He's a very good hunter. A teacher with a limited knowledge, but बच्चे को hit कर रहा है, समझ में आ रहा है, very good. Advocate, आपका काम उससे भी थोड़ा tough है, क्योंकि if आपने स्कूल में देखा होगा, हम लोगों ने भी देखा है, जिस टीचर की बातें समझ में नहीं आती है, तो बच्चे हुटिंग करते हैं, सुनते नहीं हैं. बट जो टीचर अच्छा पढ़ाता है, उसके क्लास में बच्चे बदमाशी नहीं करते. I told you in the beginning, I am more of an advocate. I am yet to function as a judge. When you face a bench, आप अच्छा पढ़ा भी रहे हैं जज को, लेकिन वो बुली है. He is not ready to listen to you. तो क्लास का जो सबसे बदमाश बच्चा है, समझो उसको पढ़ाना है. सो कैसे पढ़ाएंगे? सो यू हैव टू टेक योरसेल्फ टू द लेवल ऑफ द बेंच. एट टाइम्स यू वांट टू आर्ग्यू योर बेस्ट पॉइंट. No, come to page 50, argue this. So how to tackle that? So the art. Okay, your lordship, I'll come to that, but before, just give me a second, I want to explain this. Try to persuade. So art. And since morning, the lot of slokas are being thrown at you, and films are being thrown at you, so I'll also throw Chanakya Niti sloka. He says, Satyam vadet, Priyam vadet. अप्रिय सत्यम न वदेत. सच बोलो, प्रिय बोलो. अप्रिय सच मत बोलो. इसका क्या मतलब है इन द कंटेक्स्ट ऑफ एडवोकेसी? सच बोलो is akin to content. Whether presentation is important or content is important. Both are important. But if I have to choose between the two, content is more important. Satya. You have to prepare well. Content. सच बोलो. प्रियम वदेत. मैंने उसको अच्छे तरीके से बोलो. ऐसे बोलो कि सामने वाले को अच्छा लगे. सच को ढेले की तरह मत फेंको. प्रिय बोलो. So there comes your argument style, your skill, your persuasive skill, so that your truth prevails. अप्रिय सत्यम न बदेत. तो सच बोलने का मतलब ये नहीं है कि जो जो आपको आता है सब जाके वोमिटिंग कर देना है. No. And we have seen in many cases, you argue on one point, judge is with you, and then yes, because advocate has prepared a lot, उसको लगता है बहुत मोटी चौड़ी फी मिल रही है, ये तो 2 सेकंड में हो गया, कैसे काम चलेगा. So they start arguing. That may backfire. That may backfire. So if, but many times, we are noticing of late, judges are not expressing their opinion. You argue on one point, they are not expressing their opinion whether they are with you or not. So in that case, you are left with no option but to argue other points also. But if judges are convinced with your first 2 points, then there is no need to elaborate on other points. At times आपको लगता है risky है, so you may say कि you will put a synopsis. You highlight your star points prominently. एक sentence में you may mention other points. If something goes against you, that will be used before higher forum. So that is how you should approach. Yeah, thank you.
Well explained, sir. Well explained, sir. Very well explained, sir. Very well. Gauravji, so my question to you related to penalties, though we discussed in the earlier sessions, but still my own doubts is yet not clear, so I'm asking you again. So we have seen multiple orders where we are going to the appeal. First appeal has already gone. Now we are going to the GSTAT appeal. So in the single order, there are multiple penalties coming. So it's a company order, company's penalties, company's demands are already there. But along with that, there are penalties on the directors as well. Right? So directors' penalties are there. So now in 2 scenarios. One scenario where are 2 order numbers are there. Even if it is a single order, but orders are 2, like say 450 to 451. Something is like that is there. Then we will still presume there are 2 orders. We have to go for 2 appeals. But there is where there is a single order, say 450 only. But in that particular order, there are 2 penalties. One on the company along with the demands and other things. And there are separate penalties on either on a 1 director or 2-3 directors. So should we go for separate appeals for the directors in these particular cases or not?
Sir, I think this one issue is very clear that you have to file a separate appeal for any person aggrieved. However, you also need, as per section 107 and 112, we have to be very clear that we need a order to appeal against. So now the very crucial point, if you note what Sandeep ji said, there are not 2 orders which are served, there is 1 order served, but 2 penalties. Now there is an anomaly, there is a procedural anomaly which has been done by the clerical staff of the officer, I would say, or for that matter, the appellate authority. We need to write to them that see, and this is very evident from where you will see the copy to or to whom the order is served. So if there are dispatch orders which are limited to only 1 person, that means the order is not dispatched to other person. And unless it is served, it cannot be communicated. Unless it is communicated, it cannot be appealed against. So we have to be very clear, first of all, किसके ऊपर service हुई है, जिस पे service हुई है, he should proceed and file the appeal. So if company has received the order, let company file the appeal. The director need to write to the authority that see, I have come through, it has come to my knowledge that this particular order has been issued and there is a penalty which has been imposed, but the order is not served on me. Now please note this very particular, and this is a very trite law. The Apex Court is very clear on this. Knowledge of the order is not the knowledge of the content of the order. So while I am aware that there is an order which is against me, I am not aware about the content of the order, and therefore I request that a proper copy be served on me. So the day it is served on you, you are communicated. Now there are 4 dates, again I repeat for the sake of clarity. 4 dates are very crucial in this law. Number 1, the date of the order, on which the officer has signed the order. The second is the date of issue of the order, which is relevant from the perspective of 73 and 74. What is issue of the order? When the officer has put the order into any independent source for communication to the or for service to the SSC, and the modes are selected as per section 169. The third is the date of service. Now if you note, there are deemed service also included in section 169. Apart from the electronic media, the other mediums, there is a presumption of service, but in terms of electronic medium, there are no presumption of deemed service under 169. Last but not the least, the date of communication of the order. So I'll give you a very small example. The officer has mailed the order to me, but my mailbox is full. He signed the order on 31st, mailed the order on 1st to me. My mailbox was full. So while there is a date of order is 31st, date of issue of the order is 1st. And date of service, again it will be 1st because it is through mail. And last but not the least, the date of communication, that fails because the mail has bounced back. So while under 73, 74 there is a issuance, for the purpose of 107 and 1112, there is no communication. So the day I will get the communication, proper communication, is the date when I will be appealing against within 3 months, plus the condonation period which I. So if you have multiple penalties on multiple people, a proper service on each category or each person is very, very important. Unless that is not done, there is no appeal I can prefer against that particular order. So that's my humble view on this.
Thank you. Pramod.
In the GST 80 procedure rules, there is a provision which says joint appeals are not allowed. So there is a single order, fixes liability against the company, imposes penalty on certain persons. So every separate legal entity has to file a separate appeal. Then it says per order in original there must be one appeal. So if multiple so-called notices are disposed by a single OIO, then every legal entity has to file a single appeal. So let us say there is an order in appeal, single order in appeal, disposing 3 OIOs, and in each OIO liability was against the company and director. So technically you have to file 6 appeals. So per person, per OIO. This is one part. Second is when to file appeal. The order is because we also feel that certain provisions of GST law are draconian, like service under section 169. They upload on portal, service. So if you are not checking it regularly, it can be communicated through mail, post, even uploading on the portal, etc. And many people are missing that. Suppose company comes to know that the order has been passed and there is no separate communication to directors. But directors being part of the company, it is expected they will come to know. So should they wait for a formal communication? I will say no. The moment you come to know, file appeal. देखो, dispute करना चाहिए जब बहुत जरूरत है, जबरदस्ती dispute खरीदना नहीं है. So when you have come to know, file appeal. But somehow you miss that opportunity. It is getting delayed. You come to know a bit late. Yes, file appeal. Take that ground. It was not communicated to you. You came to know on such and such date, and therefore your appeal is within time. Marta kya na karta. And let the court decide whether service was done, not done, etc. But the moment you come to know about it from whatever sources, we should file the appeal as soon as possible. That is always better. Yeah.
Yes, please, sir. Sir, portal issues. Actually, portal, so you are right, sir. Order is one. So generally portal will allow single appeal only, but there are provision in that portal itself. You can create other appeal also with the temporary IDs, mentioning the same order. So if /1 or सबके that you can file that. Multiple appeals possible है. So problem जो आ रहा है इसमें problem because of that provision, because 10% or 20% pre-deposit is required on a penalties also. That's why the problem coming. That's why we are also asking question.
We also don't have the specific number, service number.
Service number.
The way you have, then your order number does not end on a particular common number.
Right.
There will be a specific number for each person.
Each person.
That is why, so while what I'm with Pramodji on that, and more particularly when the bench is saying something, we will file it.
Yes, yes.
I will be the first person, okay, my lords want it like this, I'll do it like this.
जो hold की हुई आज file कर देंगे.
My issue is not filing. My issue is to get the justice.
Yes. That's right. That's right. And other thing, Gaurav ji, in this communication is not even done because जो कंपनी का ऑर्डर है वो उसके पोर्टल पे दिख गया है, वो वहाँ पे कम्युनिकेशन है. हार्ड में तो आजकल डिलीवर हो ही नहीं रहा, हार्ड में हो भी रहा है तो कंपनी के एड्रेस पे. बट डायरेक्टर के केस में जस्ट एज सर सेड दैट कंपनी के पोर्टल पे आया, कंपनी के एड्रेस पे आया, तो डायरेक्टर को तो पता ही है ना ऑर्डर आया है, राइट? सो दैट इज द अगेन इशू विल कम.
Legally, you are right. When we say every legal entity has to file a separate appeal, portal is with the company. So when you upload on portal, it is communication to company. Yes. If for the purposes of appeal, they are treated different, then for the purposes of communication also it should be treated different. But what I'm saying, this is argument. Whether it will be accepted by bench or not, whether it will be accepted by all benches. See, when you say bench, I am just one dot. Not an area, not even a line. So we don't know how bench is going to treat it. See, जब अजूबा की बात आती है ना, तो जो कई बार लोग बोलते हैं कि ऐसा कैसे हो सकता है. So I give an example. आप सड़क पे जा रहे हैं, बहुत सारे सिक्योरिटी वाले खड़े हैं बंदूक लेके. Can they shoot at you? नहीं, आंसर इज यस, चूंकि उसके हाथ में बंदूक है. Can they shoot at you? उसके हाथ में बंदूक है, बिल्कुल मार सकता है. और ऐसे केसेज हैं जब लोग मारते हैं, बॉडीगार्ड्स ने इंदिरा गांधी को मार दिया, सबको मार दिया. उसके हाथ में बंदूक नहीं है. Can they shoot at you? Then answer is no. Whether they should shoot at you or not, their answer is no. They should not. But can they? The answer is yes. A very recent example. नहीं, we do not. नहीं, सवाल केवल ट्रिब्यूनल का नहीं है. Many cases as an advocate we have seen कि सामने वाले को बिल्कुल डिफेंड नहीं करना चाहिए. रेस्पोंडेंट से कि हाँ इनको रिलीफ दे दो. Do they give you relief? For issues as simple as कि credit should not form part of the cost. Daiichi Karkaria, Supreme Court took the litigation up to Supreme Court. Come duty price, very simple issue, up to Supreme Court. तो फालतू का केस. अभी लाइव एग्जाम्पल, an appeal was filed by a particular party by making pre-deposit by doing a debit in electronic credit ledger. Okay? The first appellate authority says कि you cannot file appeal by debiting credit ledger. Wrong decision. चूंकि whatever tax can be paid through credit ledger, उसकी प्री डिपॉजिट भी क्रेडिट लेजर से हो सकती है. ठीक है, आरसीएम वाला नहीं करेंगे, पेनल्टी का प्री डिपॉजिट नहीं करेंगे, बट टैक्स का कर सकते हैं. बट उसने कर दिया, अपील डिसमिस कर दिया. नाउ क्वेश्चन टू यू, तो इसका कंसिक्वेंस क्या होगा? इज फर्स्ट अपील डिसमिस्ड, व्हाट शुड बी द कंसिक्वेंस? यू हैव टू फाइल सेकंड अपील, और डिपार्टमेंट में से आई विल गो फॉर रिकवरी, योर अपील इज डिसमिस्ड. Department did not do that. The Deputy Commissioner of CGST filed an FIR. Against whom? Advocate and the taxpayer. कि you went in connivance for defrauding Government of India, जो डेबिट नहीं करना था कर दिया, और महान पुलिस ने FIR रजिस्टर कर लिया. अब उसको चेंज कर रहे हैं, तो क्या ये हो सकता है? सपोज ये एग्जाम्पल के पहले मैं बोलता हो सकता है, आप बोलते नहीं. और एडवोकेट, so now advocate goes before Allahabad High Court seeking quashing of this FIR, which has been quashed, but only against advocate, not against the party. भाई कहने को तो हाई कोर्ट कैन टेक suo motu cognizance, they can quash everything. They can also say कि file an FIR against the deputy commissioner. Why he is filing such kind of FIR? So a number of things are happening which are beyond our imagination. And again, see, I say, will that deputy commissioner is really stopped from filing a similar FIR in future? The answer is no. दूसरे को बोलेगा तुम्हारा भी कर देते हैं, तुम भी जाके हाई कोर्ट से क्वेस्ट करा लेना. What is the harm caused to him? At most, quest. So therefore, जानबूझ के मक्खी नहीं निकलना.
Thank you, sir. Thank you. So message to my corporate friends, if you are here, must appoint the consultant for filing the appeal. It's too risky. So that is one. So now, so to my panelist, co-panelist all. So one question is, please try to answer in 2 minutes only. So this is just 2-3 more questions we will ask. So question to Vaibhav. Vaibhav, in your experience, generally what type of general mistakes, common mistakes, councils do where even the good case turn to the weaken because of that common mistakes, that how you will address that?
Maybe I will just quickly list out couple of points which we discussed. Do not, argue all points with equal force. That is one point. Prepare your book properly. Don't load too much cases. When the proposition can be given by 2 cases, why to overload with 42 cases? Ensure brevity of time. Use judgment carefully. Your relief should be properly kept. You may have put the technicals very properly, but what relief you are seeking, you should be clear to that. So I think, and again, one thing is there that courtroom conduct, that is also important. It's not only technical, but how you behave. Ultimately, you are arguing a matter, not the system, not the officer. So be humble, be polite. I think these are some points. And another mistake is like, we read from the appeal. We go, we prepare an appeal, keep it there and we read it. That is not there. It's a persuasive room. So probably you need to keep the appeal as a support and have conversation more with the bench. So I think these are a couple of points which needs to be kept.
Sure. Thanks, Vaibhav. So my next question to Soumya. Soumya, this is related to additional grounds. Additional grounds, so what is my point? So when we are representing the matter on the spot, when the department representative take additional grounds or facts, which is not even part of the adjudication order or show cause notice, then what strategy we should adopt? How you will rebuttal to that?
Thank you. Again, this question can be divided in 4 parts, I feel. First is, if it is not taken in show cause notice, that means the facts were never taken into account. So if there exists an order which has not taken this fact, then in appellate level, new facts cannot be introduced unless they are extremely important for the nature of the case, and otherwise in 99.99% of cases new facts will not be allowed, especially if the department is providing such facts at a post facto level, because they are the ones who are issuing show cause notice. So then they are the ones who've done the investigation. They're the ones who've been sitting with the show cause notice for 1 year before. They have that timeline before issuing it in its finality. So they are supposed to know. Second, Sandeep ji was asking about the legal points. Again, in the appellate stage, are we allowed to, are they, the department specifically, are they allowed to add specific legal grounds? Again, the answer is primarily no. They are not allowed to add grounds which have not been taken up in the lower, say, show cause notices or in lower orders, because again, if you keep on adding or you keep on updating your arguments, etc., at every point, because, okay, so order mentioned something, so let me find out a new ground or new interpretation of this thing, then I think there's a landmark judgment, Mohinder Singh Gill, which says that then it's a never-ending litigation. You keep on updating. You update it today, I will update it tomorrow. You update the next week, I'll update the next week. So it's a never-ending process. So that is primarily not allowed, that you keep on updating your legal grounds. Facts are as it is, not allowed to add additional facts. Now coming to the side of the assessee, one point I would like to highlight, I mentioned 99.9% of times you're not allowed to add additional legal grounds. The 0.1% where you're allowed to add legal grounds is, suppose you're at an appellate stage and on the same facts, matrix, a Supreme Court judgment comes during the time of your adjudication and it entirely covers your factual matrix, and you're presenting it in the court saying, okay, the department suppose presents it in the court saying, okay, this is covering me, therefore give me the relief because Supreme Court has given me relief on a similar matter. That is the only and only time when a legal ground or a new point can be added on an ongoing situation. Otherwise, it is not allowed to, by the department side, to add a new legal ground or a factual ground. Now coming to the assessee side, again, new facts are as such not allowed to be added unless that fact helps you change the nature of the case. In that situation also, the lawyer requests the bench to remand back the matter so that new facts can be taken into account and then new order can be issued at the original level. It has to be remanded back because GSTAT does not have the authority to add on new facts and add on new grounds, etc., and then re-adjudicate the show cause notice as such. So then that is where you have to remand back the order. Again, when it comes to legal point, again it is a dicey situation. I would say 50-50, depends on if you are allowed to take the legal ground or not. If the legal ground has not been taken but it has been somewhere hinted in the order or in your past submission, then you can strengthen it. But then taking a new legal ground, if the bench does not allow, then I don't know how you will win or strengthen your case based on a new legal ground which was not thought of earlier.
Thank you, Soumya. Gauravji, just one thing from you next. So this is related to, because we all know that in initial year 17, 18 or 18, 19, there were some lot of procedural issues, whether from a GSTN side or understanding of the law side. So even I'll assume that 40% cases which will go to the GSTAT belong to 17 and 18 and 18, 19, where there are some procedural gaps. So it will be very difficult to convince the judges about that procedural gaps, even when then this lapse is not corrected during the annual filing also. So what you will suggest in those matters when you will be representing similar matters? Though it's...
See, there are two things we have to keep in mind. Number one, procedures are the handmaids of justice. So when in substance the compliance is made, the aim under Article 265 is not to push a assessee to do all the procedures.
Yeah.
But to take care of the very fact that the proper taxes are paid to the government. Number two, but we should not be unmindful of the fact that procedures are equally important. If something in the law is required to be done in some manner, it has to be done in that particular manner only. Now this particular weight of what is more important, the process or the outcome, that levy is always with the bench. If the bench feels that you have complied but you have not taken. So I'll take a very simple example of Mangalore, the Honorable Judgment of Mangalore Chemicals. There are procedures and procedures. some are substantial, some are only very technical. So if there is a breach of a substantial procedure, the bench will not be with you. But if it is merely a procedure which is a bit of a technical matter, I can very safely say that yes, you will be getting a relief from the bench. So for example, I have not filed my refund application within 2 years. It is a procedure. The section does not speak about it. There was a barrier in terms of 54. Within 2 years, I have to file. So that is a barrier which section provides. I have filed it manually. Now these are two different propositions. The first one is fatal if you have not filed it within 2 years. Though it is a procedural lapse, but it is a procedural lapse which was substantial. But if we go on to the second one, sir, I was not able to file it online, I filed it manually. That may be overlooked by the bench in terms of giving you the respite in terms of your refund. So be very, very careful of how you put your defect or deflect into the category of procedure and not in the substantial. The other side will always push it कि this अगर ये नहीं है तो ये बहुत बड़ा फ्लॉ है, और आपको ये बताना है कि अगर ये नहीं है तो ये एक छोटी सी कमी थी जो रह गई और मैंने इसको इस तरीके से पूरा किया. So please cover on to that particular count. I'm just adding to what my very learned friend Soumya ji said. Soumya ji, because I got some directions from the bench, so I'm just adding it. मैं अपने पे नहीं ले रहा, मैं bench के ऊपर डाल रहा हूँ. See, evidences when we say before GSTAT, GSTAT can allow the additional evidences. If there are evidences or the facts which were not there earlier, you have every liberty to put it before the bench with an application that these are additional evidences. It is to the discretion of the bench whether they want to. And there is where Soumya ji fills in the gap when she said that you have to portray that these were very, very important facts. If not considered, they will lead to injustice. So facts can be, and the tribunal will not be required to remand back. It can take on the facts on their side, and then they can also deliver the judgment accordingly. So I think that clarity is only what we...
Yeah, that's absolutely true. But then when it comes to factual metrics or when it comes to calculation, etc., I don't think the bench is going to sit and do... Anyway, sir doesn't like to do calculation. So but in all honesty, I have seen that they will not do calculation बैठ के. They will say कि अच्छा कुछ facts है जो नहीं लिए तो remand back करो. They're the judges. They're much higher. They'll do maths बैठ के 1 + 1 = 2. I don't think so. Yes, they will take into ground that evidences which are important and on the face of it will show very poorly or show an adverse order. So I agree that evidences can be taken on record, but most of the time...
But I'll tell you one thing. Being in indirect taxes for almost 24 years, don't so try to convince the bench. Don't try to get a remand.
Convince the bench.
अगर रिमांड में चले गए आप एक अपनी वो कहते हैं ना कि जीवन के बाद मृत्यु, मृत्यु के बाद दोबारा पुनर्जन्म, तो आप एक ऐसे चक्रव्यूह में फंस गए हैं कि आप इसमें चलते चले जाएंगे. मोक्ष की प्राप्ति की तरफ जाइए. Try to get a order from the bench.
Yeah.
Gaurav ji, last thing from you. So you are much experienced on this particular indirect taxation and representing before the tribunal GSTATs. So a lot of young professionals are there. So any message or I'll say tip from you for them while they will be representing before GSTAT, or any one of the habit they should develop?
Sir, I'm humbled that this question in presence of my guru, my senior Ashok Batra ji, is being asked from me. I would love that this particular answer would have been given by Batra sir, with your kind permission, sir. Sir, see, I would only say that what we do or what we fail, the only thing is where we don't prepare. We are looking towards the results. We are trying to become the judge. We forget that we only have to present a case. We have been paid a fees to present a case, not to get a verdict in the favor of the client. If that is the fees you are taking from your client, don't accept that fees, because you are taking your mental agony with you. You have to be very fair towards yourself. I'm not saying towards the bench, not towards the member tribunals, not towards your co-counsel, but we be very, very fair towards yourself, because you are unnecessarily putting a lot of pressure on yourself. And when you are under a lot of pressure, you will always underperform. That's the rule of the nature. So if you want to relieve yourself from that particular rule, two things. Number one, you have accepted a fees for representation, just represent. Number two, when you have taken a fees for representation, that is not those 5 or 10 minutes when you are representing. And for that matter, if the bench is with you, it will give you half an hour, 1 hour. But it will have hours and hours of preparation, which will go before the presentation of those 5 minutes before the bench. So you might be drafting it, you might be rereading it, you might be putting a paper book in place, you might be preparing a synopsis. The preparation of a synopsis is much tougher a work than preparing the entire paper book. Because what is relevant and how to put it is the most important task. That synopsis paper should be in front of you. It should be in front of the bench when you are presenting the case, and you should take it along with the flow of the synopsis through the paper book. That is the beauty of presentation which you should have. So just do keep these particular things in mind. And yes, last but not the least, I say, dekhiye, we also have to be true towards our nation. So when you are not the judge, I would only simply say, आप जो भी कर रहे हैं अपने profession में, don't try to push it. This is something which I learned from my father. I'm always looking at Batra sir for that. There are very few people who have actually undertaken a profession in a lifetime. So do respect. बहुत लंबी जिंदगी है. Profession आराम आराम से चलाना है. सब कुछ आज नहीं आएगा. जब आएगा तब अच्छा आए और जितना आए वो टिक जाए. That should be the rule. Right, sir? So keep remember Namami Matu Bharti. Right, sir? With this I close.
Wonderful, wonderful, Gauravji. Thank you so much. Yeah, sir. Right.
You should be ready with the answers.
Actually.
But that is very, very important, because at that time your strategy, your whole program may change. The
Yes.
argument वगैरह, because what he is going to say.
Yes.
So we should not forget that department representative is there to argue.
Sure, sir. Thank you, sir. Thank you, Gupta, sir. So now it's time of concluding remarks from our session chairman, Pramodji. Pramodji, just one request: when you will be concluding the session with your remarks, just add on that now, because that gesture has started functioning. So what reform you are assuming or expecting in next 1 or 2 years, one on the technology side or a policy side in the GSTAT functioning?
Right now, GST-AT is going to be an e-court. There is no physical filing. Everything is in digital mode. As a judge, when we access the portal, I am not able to see the entire appeal as a one document. It is coming in bits and pieces. There are multiple annexures, and I really do not know what is the content of a particular annexure. Suppose I want to look at so-cause notice. So I have to do fishing. Open one annexure, oh, this is not so-cause notice, open another. I see a problem when advocates, counsels are going to argue in court, how they are going to refer to the document. Ideally, my screen, minus my notes, etc., the screen, the appeal part, should mirror with the screen available to advocate. And so that is yet to come up. So we are requesting principal bench and NIC that you upgrade your portal in such a way that we are able to see the entire appeal in one document with liquid facility where you can connect different annexure, etc. And whatever we are seeing, that should be exact replica what is being seen by advocate. So this change will be good. Again, one more thing I just want to add what you said earlier. Procedural violation, etc. Hamesha dreams are dreams. So what should be, that never happens. Under American law, the taxation disputes are argued differently. They say, whenever there is allegation of violation of procedure, this, that, etc., they say, taxpayer will argue, had I followed correct procedure, तो क्या मैं गरीब हो गया रहता? Whatever is my financial outgo, today you have dragged me to litigation and I have paid X amount of tax, or I have got a refund of Y. So had I followed correct procedure, the way you are suggesting, तो क्या मुझे ज़्यादा टैक्स देना पड़ता? If the answer is no, या मुझे कम रिफंड मिलता, the answer is no, then it is merely a procedural violation. Those cases are treated differently. They are called minor cases, which may attract penalty, etc., for not following procedure, but they will not result in substantial tax liability. Unfortunately, under Indian law, there is nothing like that. At statute level, we do not differentiate. They say, you did not intimate, so you lose your credit. In central excise, you have seen a large number of disputes in that regime. Customs, import of goods at concessional rate of duty rules, etc. Even though the item has been used for the specified purpose, that is not in dispute, but because you did not register yourself, you will lose that benefit, etc. So for procedural lapses, substantial benefits are denied. Penalties are imposed, etc. And at lower level, they treat it as fraud and 100% penalty, etc. Nevertheless, before Indian court also, if you think, any party to dispute things, even if the correct procedure is followed, there is no change in financial liability. If you tell that to bench, and then you persuade the bench that this is merely a procedural lapse, which is not giving me any extra benefit, bench will be more inclined to listen to you. Bench को लगता है कि आप technical ground दिखा के substantial benefit लेने वाले हैं, then they are not inclined to listen. But you say it is merely a procedural thing. And then under Indian rulings, if something of a procedural nature is imbibed in the act itself, that is always treated as a substantive requirement, so you do not get any relaxation. For example, you have to file refund claim within 2 years. So if you file after 2 years, 5 days, you will not get it. Why? Because that condition is in the act itself. But if there is some procedural requirement in the rules, etc., even if it is violated, there are large number of decisions where they say for procedural violations, substantive benefit should not be denied. So if you argue from that perspective, probably you can persuade the bench to accept your argument. Yeah, thank you.
Thank you, sir. Thank you very much. Thanks a lot. Thank you, Gauravji. Thank you, Vaibhav and Soumya, for sparing your time and sharing insights. A lot of thanks. Over to Babita.
Thank you so much for all the panelists. So we will do a little bit from our side as a token of gratitude to present this. I'll just request our sir also to please join us, and also Shivamji, and we'll have a photograph also. Tusharji, please join us on the stage. So our heartfelt gratitude to the panelists for a truly enriching session we had, and the depth of knowledge that you shared. That was wonderful, and I think we all will be taking it forward. Thank you so much, sir. Thank you for sparing time. So I'll also request to present a memento to Soumya Panda. Sir, requesting to please present a memento to Soumya ji. Also, I'll request to present a plant to Gaurav Gupta ji. Thank you so much. Thank you for joining us today and sparing your time. I'll request all of you to please join. At least we all are there in the photograph, and also to present a plan to Vaibhav ji. We'll have a group. Thank you so much. Thank you so much for joining. It was wonderful panel. May I all request for the group photograph, please? Nanda ji, please come. Nanda ji, please join us. I also request Pawan ji, aap bhi aa jaiye. Sir, Gupta sir, please join us for a group photograph. Sir, please. You all can stand there. Last but not least, I would like to thank all the participants, those who are here to listen to such a wonderful talk, and in fact such a knowledgeable talk, I must say. That was the conference on operationalization of GSTAT. So I'm sure all of you must have gained much knowledge listening to all the expert panelists here. Thank you so much, and we look forward to have another wonderful session wherein we would like to have your presence again to deliberate on another important topic. Thank you so much to each and every one of you for joining us today here. Thanks a lot. Thanks for sparing your time and being with us for such a wonderful session. Thanks a lot. Thanks a lot for each and every one of you.